Draw near, give your attendance, it shall be heard.
Good afternoon. And welcome to the Appellate Division, First Department. We have attorneys, we have over 7 hours of argument time that has been requested today, so please keep that in mind. As I call the case, ask only for the time that you need to make your points. Understand that we have your briefs, we have your record, we're familiar with the facts of the case. And I will begin the calendar call now. People versus Jeremy Rodriguez. I'm just calling the calendar, so you will tell me how much time you would like for argument and rebuttal if appropriate, okay? So first case is People versus Jeremy Rodriguez. I'll give you 5, 2, and 5. Thank you. Nia versus the City of New York. I'm just going to ask you to keep your voices up. We all have the masks, and you don't have microphones, so I know it's difficult, but please keep your voices up. Yeah, 5, 2, and 5. Thank you. Only Properties versus New York City Department of Buildings. 5, 2, and 5. Thank you. Bickman versus New York City Loft Board. Five and 1, 4 and 4. Thank you. 69 Pinehurst LLC versus 69 Pinehurst. I don't see. Is there anyone on that side? No. Oh, okay. Give you 5 and 2 and 5. Thank you. People versus Alberto Guzman Cabra. Caba, I'm sorry. Is that submitted? I don't see anyone on these. Okay, submitted. McDaniel, this is 7 and 8. McDaniel versus the City of New York, both appeals. I am going to hear both together, of course, and the time is 5, 2, 5, 2, and 5. People versus Karan Lassiter. 5 and 1 and 4. Burgess versus Avignon Taxi. 5 and. What did you ask for? 5 and? Thank you. Is there a respondent? Do you wish to submit? There's no appellant. I'm sorry, there's no respondent. Do you wish to submit?
I would like to present to the court to speak 5 minutes.
I'll give you 2 minutes. 2 minutes in submission. FPG Maiden Lane versus Bank Leumi.
8 and 5, Your Honor.
I'll give you 6 and 2 and 5. Thank you. Wolf versus Bloomberg, LP. Who's the appellant? Okay, you go first. Excuse me? 5, 2, and 5. Thank you. Luo and Associates versus NYIS Law Firm. 5, 2, and 5. Thank you. People versus Tyrone Knowles.
For appellate, 5 and 2, please, Your Honor.
Respondent request 5, please.
5, 2, and 5. Serrano versus Brook Plaza. 5, 2, and 5. Thank you. Kirby Forensic versus Carmi.
There's two sets of appellants, and for the state, for Kirby, if I can get 5 and 2.
For the co-appellant, appellant Nassau County DA, Your Honor, that'd be 3 and 1, please.
5 and 2, 3 and 1, and 6. Thank you. Haverty versus the City of New York. Excuse me? I'm sorry.
3 and 5 for the appellant.
I knew that. Your 5 minutes you asked for? Okay. 3 and 1, 5 and 5. Okay. We're going to call a case out of turn. That would be People versus Tyrone Knowles. Justice Rodriguez is recused from that case. And the first case we are going to call is People versus Jeremy Rodriguez. I am recused from that case. So Justice Sally Ann Scarpullo will be vouched in for both cases. People versus Jeremy Rodriguez will be first. Second will be People versus Tyrone Knowles. So People versus Jeremy Rodriguez.
Give them 5 and 2. Ready to go? Okay, counsel. Go ahead.
May it please the court, Charlie Carrillo on behalf of Jeremy Rodriguez, the appellant. On April 19th, 2016, my client, Jeremy Rodriguez, was convicted for manslaughter in the first degree. On May 27th of 2016, he was sentenced to 25 years imprisonment and 5 years of post-release supervision. At the time of the criminal prosecution, he was 17 years old. On June 1st of 2020, Mr. Rodriguez filed a 440 motion with the Supreme Court of the Bronx to vacate his conviction and to set aside the judgment. On June 14 of 2020, the 440 motion was denied. In our appellate papers, we mentioned 5 basic points that we want to bring out today. The first one was that Mr. Rodriguez was denied his constitutional right to effective assistance of counsel during his trial. During the trial, the defense counsel in his opening and closing statement shifted the burden of proof to the defense.
Sir, would it be clear to say that notwithstanding arguably telling the jury that the defendant had the burden of proof when he used that term, he was pretty much trying to hit the ground running, telling the jury that they just simply had no case against your client with respect to the murder charge? And at the end, would you agree that defense counsel was successful in getting an acquittal of the murder charge, correct?
Your Honor, I do, with all due respect, I disagree with you in certain factors. One is because defense counsel, just in his opening statement, made 11 reference that were burden-shifting remarks. Second of all, the trial judge did not address this matter. The only time the trial judge addressed this matter was when the jury was outside the courtroom. And pretty much he was just letting them know, like, do you know what you're doing? Throughout the trial, from the opening statement through the closing statement until the verdict, it can be assumed, and there's a high probability that the jury's members thought that defense counsel had to prove something and he didn't. So because it wasn't addressed, the prosecution didn't object to it.
Counsel, didn't defense counsel in summation, in essence, tell the jury that it didn't have a burden, the defendant didn't have a burden, but yet it sought to prove certain things? So defense counsel himself explained to the jury that he had no burden.
Your Honor, with all due respect, that was at closing, but from the opening statement, after those 11 remarks and going through the closing statement, shifting the burden to the defense, a reasonable person can conclude that the juries could assume that defense had the obligation to prove something which he didn't, and defense did not prove anything.
Counsel, didn't the trial judge as well issue instructions to the jury, letting the jury know that the defense didn't have a burden?
Yes, Your Honor, he did. He did that for instructions, but he did that after the closing statements were ready to give the verdicts. But the situation here is that throughout the whole trial, the burden of proof was shifted to the defense from the onset, from the opening statement. So for the juries, throughout the trial, they're expecting that the defense had to prove something. Once again, it did not. Going forward, on the second point of ineffective assistance of counsel, also the defense counsel failed to object to Mr. Rodriguez's arrest photo being displayed while Detective Godino, the lead detective in this case, was giving his testimony. No objection.
Counsel, what prejudice came from that?
Because the identification wasn't an issue in this case right now. So pretty
Okay,
much.
but that doesn't respond to, what's the prejudice? He was arrested, there's his photo, there wasn't any testimony other than showing his photo. So what's the prejudice?
The prejudice, Your Honor, is pretty much having the photo during the whole testimony of the police. When the prosecution did the cross-examination, they never let the jury know that this is the arrest photo of the instant case. In other words, they don't know if it was from the past case. That wasn't clear.
Also, but was there any suggestion that that photo was from another case or from another arrest or anything to indicate propensity?
No, it did not. It was, my personal opinion, it was to bolster the credibility of Officer Godino, Detective Godino at that time, and it was prejudicial because it led to the propensity that Mr. Rodriguez had criminal activity or had a criminal record in the past. There was no need to have that photo displayed because of the fact that identity was not an issue present in this case. Moving forward, on the third ineffective assistance of counsel claim, defense counsel failed to raise the issue and circumstances of Mr. Rodriguez's illegal arrest and interrogation. Also, the 440 court pretty much failed to evaluate the ineffective assistance of counsel claim under the totality of circumstances. Here, as I mentioned before, he shifted the burden, he allowed the photo to be present at the hearing, and two, he never mentioned any of the illegal arrests that occurred in the interrogation.
Counsel? You have time on rebuttal, right?
Yes.
You have, okay.
May it please the court, Charles Wan. I'm sorry. May it please the court, Charles Wan for the respondent. Here, the trial court instructed the jury before deliberations that the...
But counsel, the problem is that the counsel made those statements about, I'm going to prove in his opening statement, correct?
He did use those words, Your Honor, but...
There was no corrective action done by the court to the jury at that point, right?
At that point, no, Your Honor, but even the defense counsel's opening, when viewed in full context, it's clear that he was merely pointing out that there are weaknesses in the people's case, and that throughout trial, he's going to point out what those weaknesses are. So the jury will find that people had not proven beyond a reasonable doubt defendant's guilt.
So are you saying he used the word prove as in, I'm going to show you this?
I believe it's really more that he's telling the juries to look out for these issues that he's going to bring out through cross-examinations to show that the people's case is not strong, in defense counsel's belief, and that when they go back to deliberate, that they will decide that they'll find that defendant's guilt was not proven beyond a reasonable doubt.
Counsel, isn't it possible that those statements confuse the jury in that after telling the jury so many times that they're going to prove whatever it is that they're going to prove, they didn't put on a case?
But, I mean, before deliberations, the trial court instructed the jury that the burden stays with the people, that it does not shift. It is the people who have to prove beyond a reasonable doubt defendant's guilt. And as the jury is clearly told not to deliberate the issue before the trial is over, they've heard all the summations and heard all the jury charge, there's no reason to believe that jury would have considered in any way deliberating the evidence until they had fully heard from the court what that the burden stays with the people, and so there would not have been any kind of confusion on the jury's part. And as for the other issues, I believe.
Well, what do you say about counsel's argument that there was no purpose of putting out the arrest photo in front of the police officer during the entirety of his testimony, except to give the jurors a false impression that he was a career criminal or that he had a propensity to crime?
I believe in the record, Detective Guarino testified that the arrest photo, that the photo is from the instant arrest. It's clear in the record that there was no indication at all on the record that the defendant had any kind of priors. It's clear that the arrest photo was from the instant matter, and there was no prejudice in this matter because there's no arguments made at all related to the photograph. The evidence was defendant's own statement. There's no any kind of argument made relating to the photograph or any kind of testimony by the witnesses as to descriptions of the perpetrator or the defendant. So the arrest photograph could not have caused any kind of prejudice in this case. If there are no other questions, people request an affirmance. Thank you.
Okay.
Yes, Your Honors.
One second.
Yes, Your Honor. Moving forward on the third point of our appellate document, Mr. Rodriguez's constitutional rights under the 4th, 5th, and 6th and 14th Amendment were violated when law enforcement, the Bronx and police, illegally seized him from his residential home in New Jersey and conducted an interrogation without a warrant.
Counsel, isn't that argument barred? You didn't bring that up in your direct appeal.
I did bring it up, Your Honor, in the direct appeal. Not in the direct appeal from the decision. I'm bringing it as an ineffective assistance of counsel that he didn't bring it up during the suppression hearing. He didn't call for a patent hearing, and that's the reason why I'm bringing it up under the ineffective assistance of counsel claim too. So I'm bringing in both. And the situation is that if you see the arrest warrant that was issued on April 27th of 2011, the address that's there is the New Jersey address, but it doesn't state the city nor the state. It was issued the same day he was arrested. Mind you, he was arrested at 5:30 in the morning. That means that the arrest warrant had to be issued between 12, let's say 4:30, give him an hour to get to New Jersey and to issue the arrest warrant and conduct the seizure of the client. Mr. Rodriguez was taken at 5:30 in the morning as a minor at 17 years old to be interrogated. He didn't go to the detention facility. He didn't go to a court. He went strictly to the U.S. Marshal's office in Newark to be interrogated. Going forward, that's when Mr. Godino wrote his statement, and because that statement is a fruit of the poisonous tree, that shouldn't have never been admissible. Nobody questioned this on the record in the trial court. The defense attorney never called for a patent hearing like I mentioned before. Under patent, this is an unlawful arrest because it was his residential home, he was a minor. The U.S. Marshals, when done a FOIA request, it indicates that they used a warrant issued by March 23rd of 2011, which is a bench warrant issued by the city of New York for a failure to appear. In that scenario, they violated their own statute because of the fact that they can't execute a misdemeanor warrant. Therefore, the arrest was illegal.
And that's another, you're bringing that under an ineffective claim, not a.
I'm bringing it as
right.
both,
Okay.
both, Your Honor.
All right, thanks very much,
Thank you very
counsel.
much.
Thank you, counsel. So I'm going to move over. Yeah, okay. I think that one will call the next case.
People versus Tyrone Knowles.
Oh, sorry. Let me get my...
You may begin. Thank you.
Thank you, Your Honor. Good afternoon. May it please the court. Marika Meese for appellant Tyrone Knowles. I'm going to be focusing on point one, the Rosario point. Reversal is warranted here on the Rosario point for two reasons. First, because the delayed disclosure of this request for commendation from the arresting officer substantially prejudiced Mr. Knowles because he wasn't able to use that document either for cross-examination of the arresting officer or in summation. And second, the court abused its discretion in denying his numerous reasonable requests for relief due to that late disclosure, which
But the
included-
judge provided a remedy, and that was to open the suppression hearing again. I don't know that it was raised again by counsel, raised it at the opening. And then you are correct, the people didn't provide this information until far too late, but the judge provided a remedy.
And that
What do we
remedy
do
was
with that?
inadequate because it did not allow counsel to use it at trial. And this document would have impacted this case, which turned on the police officer's credibility. And here, the
But
defense...
don't you have to show that there was a reasonable probability that the outcome would have been different had the Rosario not been provided?
Yes.
Had it not been?
Yes, had it been timely provided and had the people, and had the defense been able to use it, there is such a reasonable possibility that the outcome would have been different. Because that inquiry has to be examined from the defense perspective, and the defense counsel here outlined numerous ways they would have used this document. First, they would have used it for cross-examination. The document had inconsistencies between the arresting officer's testimony and between his supporting lieutenant or
So can you
sergeant's.
tell me what inconsistencies you think there are?
There were inconsistencies in the description of the object, in whether or not Mr. Knowles went into a building or was immediately apprehended. They were minor inconsistencies, but in a case where they heavily went after the officer's credibility, these small inconsistencies still could have impacted the verdict. As well, there was the major omission of having no details at all about the alleged drug transaction.
Wouldn't that have opened the door to the very benefit your client got when the judge suppressed all that information? So that
Nope.
once you open that door, you would have had far more exposure?
I don't think so, Your Honor, because the court did rule that the defense could potentially open the door, but here they would have been able to carefully probe the omission just on its face of whether or not this officer had described the drug transaction that he described in his testimony as alerting his attention to Mr. Knowles and the predicate for the stop. So an inquiry about that omission would not have opened the door. As well, the people never made that argument below, nor did the court rely on it. So this court is barred under LaFontaine from affirming on that ground. And the omission was large in this case. And again, you have to view it from the defense counsel's perspective, and they articulated other ways they would have used it, including the motive to lie argument, which would have supported their defense that these officers, in fact, had stopped Mr. Knowles because they thought he potentially looked like someone who matched the radio run for the robbery. But then when he wasn't identified by the complainant, they fabricated a case against him. And the omission of the alleged drug transaction supported that motive to lie defense. As well, they indicated they would have crossed him on his telling the prosecutor that he doesn't ever put in a request for a commendation until a case is over, whereas here he clearly had done so before. And his failed memory of having even put it in when he got a signed copy, and receiving this kind of recognition is an important thing that an officer would and should remember.
But against that, you're saying that based on that testimony, the jury would have adopted the defense here that officers are walking around with extra guns that they are planting on defendants, and that the jury would have believed that this officer planted the gun.
I think that's a reasonable position, Your Honor. In this
Planted
case,
the gun, but he was sloppy about the DNA, an officer that is so calculating that he would is able to persuade his fellow officer to ignore the fact that he's carrying around another gun, would plant the gun and be so sloppy not as to make sure that the DNA of the defendant was definitely on the gun?
Well, we don't know
not
that
just
it was
1.5
we don't know if it was
million
definitely.
times likely to be on the gun?
We don't know if the DNA was definitely on the gun. The officers
Well,
worked
that's
as
what I'm saying.
the officers worked collectively as a team and would likely support each other. And more importantly, this is a case where the jury struggled to come to a verdict. They asked for readback of the entire trial, including openings and closings and all of Officer Rivera's testimony, as well as the other testifying officer.
Okay,
They sent
you'll have some
13
rebuttal.
notes. Okay,
Thank
Your
you.
Honor.
Counsel?
Good afternoon, Your Honors, and may it please the Court. My name is Shane Magnetti, and I represent the Office of Darcel Clark. The crux of this trial was whether the defendant possessed a gun in his waistband or whether
I
the
think the
officers-
crux of the trial is the fact that there was should have been a Fry hearing on some very questionable evidence, and there was no Fry hearing. I think you admit that there should have been a Fry hearing, and there wasn't. And then that there was documents that would have fallen under Rosario, that were asked for in a timely fashion, and then never materialized, documents that the officer himself said he couldn't remember applying for, a commendation that he had to write for, that he had to fill out the application for, specifically, with facts specific to the incident, he didn't remember. This is the Rosario material that wasn't provided. So I think it's really not about the other thing. I think it's about how does this play against the absence of the failure to have the Fry and the failure to be able to give an adequate remedy in a timely fashion for this Rosario material. What are we supposed to do with that? Do we just find that it was harmless now?
Well, Your Honor, so I suppose I'll start with the DNA issue first. This case is not like, for example, Wortham or Patterson, where the DNA evidence was the strongest evidence that linked the defendant to his contraband. Here there was eyewitness testimony from both Officer Rivera and from Lieutenant Campbell, both of whom saw Officer Rivera retrieve the 9mm handgun from defendant's waistband.
But that is their defense, that he didn't do it, that he planted it. And the DNA information that you're saying is not strong. To maybe you, as a practiced attorney in this field, you might be able to see the weakness in it. But to a jury, they're hearing that it's 1.5 million times more likely that defendant and 2 others contributed to the gun sample. To a jury, that might sound like strong evidence.
Well, Your Honor, I think it's important to note here that the prosecutor did not present the FST analysis as the determinative evidence of the defendant's guilt. She even de-emphasized it in summation. She told the jury, "I am not standing before you and asking you to convict based upon the DNA testimony alone. That is just one piece of a mountain of proof." She said that the people had met their burden with just Rivera and the ballistics expert, and they didn't need to go further.
You're right. It wasn't just that one piece. It was the fact that, given what the DA said about it, not just being that, they were relying on Officer Rivera to be truthful. And yet, there was evidence that he had already had issues with the Civilian Review Complaint Board, and on the fact that when they had this hearing ahead of time, he couldn't remember a thing about this commendation that he himself applied for, that all came out at the later suppression hearing.
Right, that's true, Judge, but I think it's important to remember here.
And by the way, I don't think there would have been a question that the judge would have given a limiting instruction, but that the jury was already in deliberation.
That's true, and I'm not saying that, obviously this Rosario should have been disclosed far earlier, but the fact of the matter is it was disclosed in deliberations, and now we're dealing with an abuse of discretion standard. And that's the situation that Judge Lieb found herself in, whether to give an adverse inference or grant a mistrial or grant the 330-30 motion at that point in the proceedings.
So I ask you again, why should we find it harmless? These two pieces of the puzzle that didn't work the way they should have, the Rosario and the Fry, why should we find
Yes,
this
Judge.
harmless?
So the DNA should be found harmless because the element of possession was established even without it. There were 2 eyewitnesses to the gun being retrieved. There were photos and evidence that corroborated Rivera's testimony that he saw the L-shaped bulge in the waistband, and the DNA, the prosecutor de-emphasized it. This case is more like Foster Bay or Williams than like Wortham or Patterson. So that's for the DNA. As to the Rosario material, defendant has not shown substantial prejudice because she didn't have it. The request for recommendation did not even contain any outright inconsistencies. It contained an omission of conduct that the defendant was not on trial for. He was tried only on the gun charge, not on the drugs, and therefore it really did not prejudice him in regards to that. I see that my time is up. Unless your honors have any questions, I'll ask that you affirm.
Thank you.
Thank you.
In terms of the Rosario disclosure, you have further evidence that it would have made a difference here because you had the juror affidavit where a juror swore that if they had received this information, they would not have voted to convict. And that gives you further evidence that indeed this substantially prejudiced Mr. Knowles. As well, in terms of the reasonable requests for relief that the defense made, they were made at the juncture based solely on the fault of the people and the delayed disclosure. And yet the court faulted the request for an adverse inference as being delayed. When at the time of the...
Wouldn't you usually make that request during the charge conference?
Absolutely, but at the charge conference...
Did counsel make that request during the charge conference?
At the charge conference, the people had yet to disclose that this document in fact existed, and so there would have been no basis to ask for an adverse inference on a hypothetical document. But prior to that, defense counsel had in fact asked for a hearing to determine whether it existed and emailed the people daily to request this document. The people were aware it existed prior to summation. They remained silent, and so the defense can't be faulted for that failure to disclose or the late disclosure. And then just turning briefly to the DNA point, Your Honors, we know that jurors give extraordinary weight to DNA evidence, and here, as Your Honor noted, this was a high statistic that for an untrained scientific jury sounded like a very strong evidence. And the people didn't just sidestep the DNA evidence, they relied on it to corroborate their officer whose credibility had been substantially attacked by the defense, and they relied on it to say that it was supportive of the conviction. So that is harmless error, and that should also warrant reversal here. If the court has no additional questions, I will rest on my brief.
Thank you. Thank you both. While we wait for Justice Rodriguez, I'll call the next case, which is Naya versus the City of New York.
Good afternoon. May it please the court. My name is Susan Pepitone. I am the attorney for the appellants. This case is essentially about plaintiff's right to keep her 9-year-old daughter safe and to be allowed to go to the family court if there is a change in circumstances in visitation with the father. And the police officers in this case.
Counsel, you've brought a claim for intentional infliction of emotional distress, right?
Yes.
And aren't those claims against the government, against the police, aren't they barred as a matter of public policy?
The
Don't
intention.
they have immunity from these kinds of actions?
The intentional infliction of emotional distress claim, when there is material questions of fact, that this claim should not be dismissed on the merits. And the outrageous nature of the conduct can be established when it arises from abuse of
But there has to be some intent to create harm. There are no factual issues here, really. I mean, even if you take the facts as you state them, the police had an open visitation order for the father. That was the reason why they were at the home, to remove the child. There was no intentional desire to harm the child. They removed the child pursuant to a valid court order.
Well, there is a lot of nuance in that. 3 days prior to the police removal of the child, the mother went down to family court and was seeking an order of protection for the daughter. The daughter had become extremely ill as a result of longstanding domestic violence in this case. And she had a petition in family court to amend that order. So the question is...
Well, counsel, that may be true, but the fact is that at the time that the police went to remove the child, there was no order of protection in favor of the child and against the father, and there was a valid visitation order, correct?
That's all correct. In addition to that, there was a petition in family court where a family court judge would review this case. And there is also Section 652 of the Family Court Act, which allows a parent to go to family court and have the visitation order amended or suspended based on a change of circumstances. So in other words, the police cannot play Solomon and decide that who should have a visitation.
Let me just ask you, at the time, was there a valid visitation order in place at the time the police went to the apartment?
At the time, that visitation order was in the process of being amended.
That's not what I asked you.
I,
Was there a valid visitation order at the time?
You could say it was valid. The only
And so
point.
how are you going to, you can say there was a valid order. Another order had not displaced that yet. So
But-
when you have a valid order and you have, this intentional emotional
Stress.
distress, how do you overcome that kind of long-standing public policy against these kinds of actions, against government or police action? I mean, how are you going, what are we supposed to do with that?
My response to that is that she has a right to go to family court and have that amended at any time due to a change in circumstances. So even though that order is valid, the police have no way of knowing if it's valid.
But that's more in favor of this action not being brought against the police.
They have to find out. They have to find out whether or not the order is valid before they enforce it. There's a long-standing policy since
Counsel, even under your premise, if the police investigated and went to family court, they were only going to find that the father had a valid visitation order, correct?
They would also find that the mother went to family court
But
and
the
has
fact
a
that the mother
petition.
puts in for a modification didn't affect the validity of the order in place on the date of the incident, right?
It should have. It should have, because the
I'm
family
sorry,
court.
you said it should have?
Yes, because.
By what? By operation of law? There's no such thing.
No, of course. But what happened in family court is it's an extremely busy court. If people come in and they want an order of protection, they have to be heard by a judge. At some point, the court closes down and they tell people.
I think you said it. When you said it, they have to be heard by a judge. But you'll have some rebuttal where you can pick up your argument. Thank you.
Good afternoon. May it please the court. Rebecca Viscatus for respondent.
Counsel, how do you respond to your adversary's position that there was this amendment pending? What does that mean? What does that do?
So the evidence that plaintiff presented was that she had gone to court and filed a family offense petition seeking an order of protection, but even in the petition, that order of protection the order of protection she sought would direct the father to stay away except for court-ordered visitation. Now, her ultimate goal may have been to amend his visitation rights, but that's not even what the petition that she offered in evidence in this case sought to do. And in any event, as Your Honor has recognized, she has never disputed that the order that was in place at the time remained valid. She had a right to go to court and to seek amendment of the father's visitation, but that hadn't happened yet. And the order that the police were enforcing at the time, she did not dispute the validity.
Counsel, what do you say to the argument that the police violated their own procedures by enforcing this family court order when they have a policy not to?
This court has held that violation of internal police policy is not enough to establish liability even in a negligence claim. And here, with an intentional infliction of emotional distress claim, that's clearly not enough, especially to hold the municipality liable for the officer's actions. And in fact, as Your Honor recognized, this entire claim is barred against the city as a matter of public policy. That is well-established statewide precedent that a claim for intentional infliction of emotional distress does not lie against a municipality.
What about the violation, if you will, of the internal operating procedures vis-a-vis these family court orders, coupled with the timing of the officer's action? It was, I think, 10 o'clock at a school night?
Sorry, what was the end of that?
Oh, what do we make of the timing of the police officer's actions, which was at 10 o'clock at night on a school night, coupled with the violation of the protocol, the internal protocols?
Essentially, the police were responding when they received a call and when the situation happened.
What does that mean? You're saying they received a call from the father at 10 p.m.? Is that what you're saying?
That the father called, and by the time this was routed to these officers, it was 10 o'clock. It wasn't like there's no indication that they intentionally sat on.
Does that make it okay? I think that's what my colleague is asking. What do you say about that? They take a child who's 9 years old out of her mother's home at 10 p.m., perhaps even pull her out of bed, and she goes. No one's denied or challenged that she went dragged out of there, screaming. 9-year-old. That couldn't wait till the next day at a reasonable time?
Well, the visitation that the father was seeking to enforce was only for that night. So in order for
And that seemed reasonable.
I mean, that's not really the standard, whether it was reasonable.
It must not be. Because I think we'll all agree that was not at all.
Sure, and it's entirely... These officers may not have made the right decision in retrospect in this situation, but there's no indication that this rises to the level of conduct, the outrageous behavior beyond all bounds of decency.
I think the question that my colleague asked, maybe I'm wrong, you can repeat it, but was whether or not, how this sort of sits with the internal policy of not exercising these kinds of orders for the very reason.
And that may well be part of what influences this policy, and there may be good reason to revisit that in the future. But here, the officers, there's no indication that they were intending to inflict emotional distress, intending to act in
Right, because if we had to employ the best interest of the child standard here, which we do for everything, not in this case, clearly, it certainly would fall short.
Sure, but the fundamental fact here is that the family court was the one who had decided that it was in the best interest of the child for the father to have visitation every Thursday night.
Talking about the
into
10
Friday.
p.m. and the way it was.
I understand, Your
addressed.
Honor. If I can briefly address the plaintiff's federal claims.
I'll give you 30 seconds because your time just ran out.
Sure. Fundamentally, the plaintiff's claims under Section 1983 are about a single incident, and she failed to state a claim because she didn't allege sufficient facts to show any specific city policy or practice that resulted in any purported constitutional violations.
Thank you.
Thank you.
I do just want to mention that it's not only an intentional infliction of emotional distress claim, but plaintiff has claims for 1983 claims and violation of her constitutional rights.
Thank you.
Thank you.
Thank you both. Only Properties versus New York City Department of Buildings.
Good afternoon. May it please the court. Nicole Wachneen on behalf of the appellant petitioner, Oli Properties, LLC. We believe the Supreme Court erred in dismissing the appellant petitioner's Article 78 petition as moot, first and foremost because the underlying summons was dismissed pursuant to a superseding decision that was obtained in violation of oath's own procedural rules, and therefore the superseding decision withdrawing the summons should be treated as a nullity. Second, the superseding decision, which dismissed the summons, contained language reserving the right for the summons to be reissued based on the same facts, therefore preserving the controversy in this case. Appellant's petition...
Well, I'm sorry, but is it a controversy or a potential controversy? Because we obviously need a live controversy, otherwise this would be moot.
Yes, I think because it's not that the way they phrase it basically is that they can reissue the summons on the same facts so that the DOB would not have to send an inspector down there to observe another violation and issue a summons. They could reissue the summons and re-prosecute the same facts that they observed back in December of 2019. And that, I think, is the distinction and why there still is a live controversy in this case, because they've clearly indicated a right to come back and re-prosecute not a future violation, but the same violation at issue in the original summons.
So they didn't expressly, in dismissing the summons, state that that's what they were going to do, but there is a possibility, the door is open, because the dismissal, if you will, wasn't with prejudice.
Correct. They reserve the right to re-prosecute the same facts. But first and foremost, short of following the procedure set forth in Title 48 of the Rules of the City of New York, Section 315B, there is no other way to obtain a superseding decision after an appeals board decision. Clearly, the DOB did not follow the procedure set forth in 315B, as they only had 10 days to seek a superseding decision, and here they waited 4 months before they saw a superseding decision. Further, their request for a superseding decision, titled A Request to Adjudicate by Mail, falsely stated that they were submitting the request on behalf of the appellant. They later had to go back and submit a corrected version of that form 3 months after that, so we are well past the 10-day deadline set forth in 315 Section B.
Sorry, Counselor, are any of these dates hard and fast statute of limitation type dates, or are they dates that in the agency's discretion it could extend or overlook their failure to comply with?
I believe the language in Section 315 sets a firm 10-day deadline. It says within 10 days of the mailing of the board's appeals decision, a party may apply to the board for a superseding appeals decision. So I think that it is a firm 10-day deadline.
Counsel, why shouldn't the Department of Building be able to withdraw its summons at any point? I think most people would welcome the opportunity to have the summons withdrawn.
Well, because I think, as a matter of public policy, the whole purpose of an Article 78 proceeding is to allow litigants the opportunity for judicial review of city agency actions. If a city agency can unilaterally dismiss a summons, even after adjudication at the trial level, appellate level, and the filing of an Article 78 petition, they're basically undermining the entire purpose of the Article 78 proceeding. And combined with the fact that they have indicated a right to come back and re-prosecute the same summons and under the same exact facts, they are in effect playing litigation games that you often see in civil proceedings. We all know litigation is costly. If a litigant has to keep coming back and litigating a case through the oaths trial, through the oaths appellate process, and then through the filing of an Article 78 in Supreme Court, most litigants are going to run out of money and cannot afford to do that over and over again.
Well, let's say they did that. Let's say that, take that hypothetical, that they did turn around and issue a new summons against your client for the exact same alleged offenses. Then you prevailed on the merits before the administrative board, or you lose before the administrative board, take a new 78, prevail before the courts. Wouldn't you then be entitled to relief under the Equal Access to Justice Act and get costs and attorney's fees for that?
Possibly, but that would still involve the litigant fronting the cost to get to that point. And it is still a costly and time-consuming procedure to go through the hearing at oath, the appellate process, and the filing of an Article 78 petition. Thank you.
You have rebuttal.
Good afternoon. May it please the court. Eva Jerome from the New York City Law Department. There is simply no live
Is the Department of Buildings circumventing the whole purpose of the Article 78 by withdrawing it at this late stage, by withdrawing the summons?
Absolutely not. There's a specific rule in the rules of the City of New York, 6-08E, that contemplates the withdrawal of a summons even after there's been an adjudication and even an appeal. And this court has found, even when pending Article 78s, even when there were pending Article 78s, that the agency's withdrawal of the summons mooted the issue.
I guess the real question is, what's the purpose of doing that here?
I don't know except for what it's in the record, and it said that based upon its review of the files, I believe the language is,
They weren't prepared?
No,
they hadn't done enough review? I mean, I don't understand, because they leave this open. It's open. They say they can revisit it again.
Well,
what is the purpose of withdrawing this?
There's no evidence.
If they can't just end it now without leaving this open-ended suggestion that they're coming back.
Well, DOB did not put the language in the oath superseding decision that said the agency has the right to issue another summons based on the same facts. What that language refers to, I believe, is the fact that DOB has an ongoing obligation to fulfill its duty to the public, which is to always ensure that.
And that goes without saying.
Right.
So it's still unusual then that it needs to be put in that way, that the DOB doesn't have experience enough to know that this is something they can do?
Well, I don't know what oath that oath
I
ALJ's
understand your answer.
thinking was, but DOB definitely wasn't there to say, I want that language in. And petitioner can't dispute the fact that the publicly available website shows that there are 0 open violations and 0 pending hearings, that the hearing status is dismissed, that the violation is resolved, and that there is simply no live controversy here.
Counsel, what protections or remedies does a petitioner such as someone in only properties position have if they are subject to successive administrative type prosecutions? That ultimately, one important cherry on top of that, that they ultimately prevail in, the petitioner.
Well, I think, as you mentioned before, there's the ultimate recourse of getting attorney's fees, but this is a hypothetical that the petitioners undercut their own argument by only being able to point to 2 cases 25 years apart. And if DOB is issuing thousands of summonses and they haven't pointed to one other instance of this happening, this is just simply a fear-based or extreme conjecture on the part of the petitioner. And there certainly is none of the prongs to the mootness exception have been satisfied by petitioner, and it's their burden. And of course, if the court is inclined to find that the issue is not moot, we request the remand for an answer, because DOB never answered the petition. Thank you. If there are no further questions.
I just want to address the rule in section 6-OEE that the respondents are relying on. And there are a couple of reasons why I actually do not think that that applies to a case that's been adjudicated through the appeals as opposed to just the hearing level. First and foremost, in Chapter 3 of Title 48, Section 3-12, it specifically states that when there's a conflict between the rules in Chapter 3 and Chapter 6, Chapter 3 should prevail. So if the court finds a conflict between 3-15 and 6-OAE, I think the statute says that the rules in Chapter 3 have to prevail. Second, if you look at the definition set forth in Chapter 6, Section 6-01, they define oath hearings division and appeals units separately. So I actually think that 6-OAE only applies to adjudication through the hearing level and not the appellate level. And finally, I think there's further support of that if you go down to Section 6-19, subsections G1 and 2. Both of those subsections make clear that the appeals board decision is the final determination subject to Article 78 review, and then it lists certain exceptions. One of the exceptions is if you follow the procedure set forth in Section 315. They do not list Section 6-OAE, which I think also signals that they do not believe that is an exception to the rule that an appeals board decision is the final determination subject to Article 78.
So your argument is that once the appeals board has ruled that the agency can no longer withdraw its summons, that's a dangerous proposition, isn't it?
Well, I think except for the exceptions that they set forth in that section, one of which is 315, that they do have 10 days then to apply for a superseding decision withdrawing the summons. I think part of the reason that they set forth these rules is for the public policy reason of the entire purpose of the Article 78 proceeding is to apply judicial review to city agencies. So I think if you set a new rule that cities can always unilaterally dismiss their summons at any stage, it undermines the Article 78 proceeding. Thank you.
Thank you. Thank you both. Bickman versus New York City Loft Board.
Good afternoon, Your Honors. My name is Charlotte Bickman. I'm an attorney, and I'm before the court today in my capacity as administratrix of the estate of Minda Bickman, the petitioner appellant in this matter.
Counsel, let me just start off asking you both. The basis of your relief today seems to be issues that we addressed already on appeal. One, in 2001, when we decided that possession of that loft was given to the landlord. The next one was in 2008, when the appellate division decided that you, the estate, I should say, of your sister, which you were the administratrix of, was entitled to the value of the appraisal and the fixtures. You are still now asking for possession of the apartment, of the loft.
Yes, well, what the Court of Appeals actually said was that the estate of Minda Bickman was entitled to recoup the value of the improvements pursuant to MDL Section 286.6. And that statute states very clearly, it provides that the Article 7C protected tenant may sell improvements to an incoming tenant. Again, the Court of Appeals ruled that the estate had the same rights as the tenant would have if she were alive. And as I stated in my papers, the Court of Appeals ruling is consistent with the legislative intent to preserve the units as rent-stabilized housing. Sale to an incoming tenant preserves the unit as regulated housing. Sale to the owner deregulates the premises. The loft board's construction of MDL 286.6 to bar the estate from selling to an incoming tenant so the owner can deregulate the premises is inconsistent with the legislative intent. So the Court of Appeals did not
I don't think that the Court of Appeals overruled our decision. I think they affirmed our decision.
There are two tracks. You first mentioned in 2001, that was the result of a housing court case against Charlotte Bickman in her personal capacity. That went up to this court, and the court affirmed there weren't succession rights. With regard to the estate, in 2001, the landlord brought an application to the loft board for an abandonment order deregulating the premises. The estate, in my capacity as administrator of the estate, I opposed that because I made it clear, the statute clearly provided that it couldn't be deregulated unless and until the owner purchased the improvements. So the issue for the loft board at the time, the loft board's position was death deregulated the premises, and that clearly was not in the statute. It was outside the scope of the statute. That issue came up, made its way up to the Court of Appeals. And the Court of Appeals says very clearly, the question before us is whether the estate can recoup the value of improvements pursuant to MDL 286. Again, the Court of Appeal ruling that the estate is essentially in the same position as the tenant if she were alive, that's consistent with a state law which states that the fiduciary, the administrator or executor, basically stands in the shoes of the decedent. So whatever rights the decedent and obligations the decedent had, the estate has those rights. And in this case, that's the right to sell the improvements to an incoming tenant. So the loft board in this case, the loft board allowed the owner to collect an illegal commercial market rate rent for the premises. The loft board failed to abide by the Court of Appeals decision, and the loft board failed to follow its own rules for sale of improvements. As a result, the determination below and the Supreme Court determination affirming the loft board ruling affected an error of law, and as I state in my papers, the appraisal, which was done by the general counsel for the loft board, violated all of the loft board's procedures for appraisals. And I note that in respondents' papers, there was a statement that, the rules only apply to a challenge application, the requirement of an appraiser, a hearing, et cetera. Well, that's not correct. If you look at
Thank you. You can finish up. I gave you some extra time. I thought you were going to come to a conclusion.
If you look at 2-07A, it states very specifically, if there is no offer from an incoming tenant, the loft board can
Thank you. Counsel,
determine
finish.
the value according to the rules and procedures.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. I'm Alan Racines, representing the New York City Loft Board. Your Honors, I think what's happening here, respectfully, is that Ms. Bickman is simply misunderstanding what the Court of Appeals did. The reference to 286.6 is simply making the point, in the Court of Appeals decision, is making the point that the fact that the former tenant is now dead doesn't prevent the estate from recouping the value of the improvements, which was the issue in the case. In that case, what had happened was the loft board found that the estate could not recoup the value of the improvements. So the Court of Appeals, in determining otherwise, was simply saying that in that sense, the estate had the same rights that a tenant would have. What Ms. Bickman wants to do is to say that that means that the estate can act as though it's still the current tenant, which just isn't supported by the law. It isn't supported by the form that the estate serves in the landlord. And what it resulted in was that the sale of improvements disclosure form proposed a transaction that was invalid on its face. And it was invalid on its face, Your Honors, because it listed Minda Bickman as the outgoing tenant, said that she would be moving out in August of 2011. Now, sadly, Minda Bickman had been dead since February 1997. So there's no way that the transaction it proposed could be valid. And as you said, Justice Renwick, this court has already held that the landlord has the right to the exclusive right to the use and occupancy of this loft. So there's no basis for saying that the estate has any ability to possess the loft, or that in any way it should be treated as though the estate somehow still lives in the loft, or that the decedent still lives in the loft. Your Honors, quickly on the valuation issue, there really is no dispute. There's no big dispute anyway. It might be some minor dollars and cents dispute between, if you were to look at it in great detail, between the valuation of the estate's expert, which was in October 2000, and the landlord's expert, which was many years later, about the value of the improvements. The
value of the improvements are those improvements that were there prior to the passing of the tenant, Minda, which would have been 1997 or before.
That's right, Your Honor. So, and that's the key point, Your Honor, is precisely that some of the improvements that are discussed by both of the experts in their reports postdated Minda's death. And as a result, about $32,000 of the approximately $45,000 figure that the estate's expert gives should be removed, and that's what the landlord, the landlord's expert said that, and more importantly, the loft board said that those values should be removed because they were made after Minda had died. And once you account for that, you have a valuation of the estate of about by the estate's expert of about $13,000, a valuation of the landlord's expert of somewhere around $14,000, but then the landlord depreciates that for present value because, again, that was many years later that the landlord's expert did the valuation. And even that small difference can be between the initial terms before depreciation can be explained by the fact that the landlord's expert had a few additional improvements included that happened while Minda was there, but that were gone by the time even the first expert took a look. So we ask that the court affirm, Your Honors. Thank you. Thank you, Your Honors.
Good afternoon, Your Honors. Magda Cruz for the owner respondent in this very long, protracted case. My firm actually represented both the prior owner, 595 Broadway Associates, and 168 Mercer Street LLC, which is the current owner. And we have been on this case since its inception, where we made many appearances both before the appellate term and this court concerning possessory rights. And as far as now the 11th lawsuit that has been brought by this petitioner, on now the issue yet again of possession, obviously we read the Court of Appeals decision and we conclude necessarily that its plain words say that the estate at this juncture only has the right to recoup the valuation of the fixtures and the improvements. There is no other construction that you can make from the words of the Court of Appeals on this case, which, as Justice Renwick correctly stated, it affirmed this court when it also held that the estate can only recoup the cost of the fixtures and improvements. I would only like to indicate a factual point that the petitioner keeps raising. Otherwise, I agree with all of the legal points that the Corporation Counsel has set forth. This loft is still rent stabilized. It has not been deregulated. It has gone through multiple tenants since the owner acquired possession back 21 years ago in 2001. Respectfully, Your Honors, there's been no error committed by the Loft Board here or the Supreme Court, and we respectfully ask that it be affirmed, both those orders be affirmed in their totality. Thank you.
Thank you. Ms. Bickman, you have 2 minutes rebuttal.
Your Honor, 3 courts ruled that the housing court litigation, which was subsequently affirmed by this court, had no bearing on the state's rights to sell the improvements under MDL 286-6. This case is not about Charlotte Bickman individually. It's about preserving the unit as rent stabilized. Contrary to the representation made just now by the owner's counsel, the record shows, it's part of the record, that the loft has been rented out to commercial tenants since 2002. There was a lawsuit brought by the owner against Farrell Robbins LLC. That documentation is in the record, and has continued after that with a variety of commercial tenants. It has not been entered into the rent stabilization system. Now, they also failed to note regarding appraisal that under the Loft Board rules, the owner has no right to challenge the fair market value in the disclosure form if the unit was not properly registered when the disclosure form was served, which was June 23, 2011. The record demonstrates that the owner fraudulently and falsely certified that the unit was deregulated in the registration that was for the period starting July 1st, 2010 and expiring June 30th, 2011. So on June 23rd, the registration, in effect, fraudulently stated, crossed out reg for regulated. The owner put in BUIR, which designates by rights, meaning bought rights.
Ms. Bickman, based on everything we've heard today, there's nothing that I have seen or read in this record that allows you, as the estate representative, to gain possession of this loft space as a rent-stabilized tenant. Nothing. All I've seen on this record is that you, as the estate representative, can validly seek a claim for the value of those improvements historically in the apartment when your late sister was there. So you can go, whether it's rent-stabilized, whether it's deregulated, there are all kinds of issues out there. But there's nothing that I can see here under the laws and rules that allows you to gain possession to get the value of these improvements. So I don't respectfully understand where we're going with any of this.
Okay, the rules do say that the sale of assets of the improvements to the incoming tenant includes the right to occupy the unit.
Thank you. Thank you all. 69 Pinehurst versus 69 Pinehurst, LLC versus 69 Pinehurst.
May it please the court, of course, Magda Cruz. I represent the plaintiff appellant here, 69 Pinehurst LLC, in this appeal concerning the dismissal on, pre-answer dismissal of my client's complaint, which sought to recover a tax refund that the defendants improperly kept in violation of their agreement.
Counsel, when you say improperly, kept, and you talk about the agreement, I'm glad.
Yes.
If you can tell us where in the bill of sale the seller your client got the right to keep the tax refund. I know that in the, pursuant to 11(1)B, I think.
Yes.
He had wanted to make sure that the seller paid all taxes that were due and owing before the closing, which makes perfect sense.
Right.
But then, once that happened, after a time, he applied for the J51 rebate, and now he wanted the rebate for all of those taxes that were paid by the seller.
Yes.
So I'm just wondering where in the bill of sale it said anything about his entitlement to a tax refund, and also if you could speak to RPTL 726, which states 1B, that real estate taxes should be, rebates should go to the person who paid the tax.
Yes. So I'll start with the first, which is where in the bill of sales it provides for my client to recover. You are correct. Of course, Justice Renwick, there's no specific reference to tax refunds. Rather, there is a general reference in the bill of sales. This is at page 40 of the record, which states that as of the date of the closing, the seller is assigning all of its rights, which would, we argue, include any rights that it had to tax refunds that predate the fiscal year of the closing, because the apportionment, which is set forth in the PSA, in the purchase sales agreement, that defines what is the period of time for tax refunds that would be adjusted at closing. It very specifically, I'm now referring to the PSA, defines that it's only the fiscal year of the closing, which means 2017, whereas the tax refund at issue concerns overpayments of taxes made between 2013 and 2016. So the bill of sale specifically states that the seller is assigning all of its rights to such claims, including the proceeds of any claims, even which may not be assignable, and the causes of action arising out of any transaction occurring on or prior to the date hereof with respect to the premises. And for that reason, we maintain that the bill of sales would cover that tax refund. And as far as the Department of Finance having improperly sent the tax refund that was, again, solicited by my client over a year after the closing occurred, clearly pertaining to a period of time that predates the fiscal year of the closing. And the Real Property Tax Law, Section 726, authorizes the Department of Finance to issue a refund either to the petitioner in an application for a refund or other person paying such tax or other levy. We maintain, Your Honor, that, and we allege in our complaint, that A, we are the petitioner of that tax fund, and B, that we are the lawful assignee pursuant to the bill of sale for that refund. And the Court of Appeals held in Adam J. Associates versus Board of Assessors that an assignee of the party who paid the tax is entitled to the refund. Simply stated, and in conclusion, when our complaint alleges these very specific elements of breach of contract, fraudulent conveyance of monies that pertain to my client, conversion, and the other causes of action in the complaint, we maintain that those allegations are sufficient to have survived pre-answer dismissal. And in fact, the Supreme Court below found that there was a conflict, and upon finding that there was a conflict between the contract of the PSA and the bill of sale, just on that, the court should have found that this matter should proceed.
Thank you.
Thank you.
You have rebuttal.
I
Thank you.
reserve 2 minutes.
Yes, you did.
May it please the court, David Friedman for respondents.
Counsel, did the bill of sale assign the rights to this claim? Or did the bill of sale, was the rights that were assigned, were they associated with the real property, the premises that were purchased?
Judge, you hit the nail on the head. So the bill of sale has the words, with the premises. The assets are assigned that run with the premises. The statute you cited, the apportionment clause that you cited in the contract all show that a tax refund is personal. It goes to the person that paid the tax, regardless of whether there was a sale or not. And all the cases we cite and all the cases that they cite, support that because it's the express words of the statute. So if there was a right to an adverse possession or a defense to that or an easement, a title easement on the neighbor's driveway, for example, that would run with the property and that would be picked up by the bill of sale. So the contract, the contract has the typical clause of apportioning the taxes as of the date of closing, not at the date of closing, as of. And it says, as the court pointed out, that the property will be closed on and all taxes will be paid to that date. That's what happened. The purchaser got what it bargained for, and by this claim, it's seeking a windfall. If it were to get this tax refund, it would get the property and they get the extra money that it wasn't entitled to, because the seller paid for it, not the purchaser. They could have put in an extra sentence that said, any refunds in the future, we're going to keep. They didn't do that. In their own rider, 13.5 of the purchaser's rider, they only reference the year of the closing. And they give themselves the right to consent to any application for a refund for that year, because that's the 1 year where the seller would get the first months of that year, and then after the closing, the purchaser would get those months of the refund, and they wanted the right to consent to that. So they could have, in that paragraph, said, talk about the prior years, but they didn't. So it's the purchase agreement is consistent in the 2 paragraphs that talk to tax apportionment. In the body, it talks about by year, so the years before the closing go to the purchaser. And the rider talks about the year of the closing, dealing with the fact that there might be a split in that year, and both parties will take some of that refund. I would point out that if they want, another way they could have done this is they could have bought the whole company. They could have bought the shares. They would have got the bank accounts. They would have got the accounts receivable, et cetera. They would have gotten this refund. They didn't do that either. So there were various ways they could have contracted to get this right. They simply failed to do so. If the court has no further questions, I'll yield. Thank you very much. Oh, just one. There are other claims, as the court below found. If you find that the purchaser was entitled to the tax refund, the quasi-contract claims and the fraudulent conveyance claims would fall away, and I rely on our brief for those arguments should the court feel the need to review them. Thank you.
Thank you.
The points by defendant's counsel really relate to perhaps a summary judgment motion. This is not a summary judgment motion. We are talking about allegations only and whether our complaint stated viable causes of action. My adversary wants to have a definitive ruling that there is no viable cause of action for those tax refunds. And even the lower court found that there was a conflict between the purchase agreement and the bill of sale for that specific claim. Yes, I do understand that the tax refund could be construed in a manner that is personal to the entity that paid it, but that is not what the bill of sales transferred. The bill of sale is very, very general. All claims, rights, and causes of action that have occurred prior to the closing were transferred and assigned to the buyer. And as far as tax refunds specifically mentioned in the purchase agreement, there is a time limitation. It is not as of the date. There was a specific delineation of what the apportionment and adjustment apply to. And therefore, Your Honor, I respectfully request that the lower court order dismissing my client's action be reversed and allow us to be able to perhaps engage in further discovery to understand the intention of the parties when they entered into these two agreements, but not to dismiss this outright. $85,000 was at stake here, and the defendants represented there were no tax certiorari proceedings at the time of closing. My client made, just in the course of normal business, solicited a tax audit and acquired these interests that clearly preceded the closing and were not limited by the provisions that the parties had agreed to. Thank you.
Thank you. Thank you both. McDaniel versus the City of New York. You may begin.
May it please the court, I'm Carl Zamers, and I represent Con Edison in this case. Con Edison, along with the other defendants in the case, moved for summary judgment, and in its papers said that if summary judgment is not granted to Con Edison, then summary judgment should not be granted to its subcontractors, Trimacine and respondent Stepmar. The only issue that Con Edison is appealing is
the grant of summary judgment to Stepmar.
Correct, Your Honor. And in Stepmar did not, when it...
So Stepmar finished its work, and Con Edison signed off on the work as satisfactory.
Correct, but that's not dispositive of the fact as to whether Stepmar performed its work in a non-negligent manner. Stepmar has to prove, as a movement for summary judgment, a prima facie entitlement to summary judgment. It did not. Its contract required it to compact and fill before laying down a concrete base. It was required to keep compaction records. It did not, or did not have them.
So when Con Edison approved Stepmar's work for the subgrade work, what were they approving? What were they saying was satisfactory and complete?
Well, in the contract itself between Stepmar and Con Ed, the general conditions, Con Edison represents that we are not, we are saying that at the time of the inspection, there were no issues, but that did not absolve the fact as to whether there were any underlying issues. There is contract language to that effect.
Are you talking about indemnification, or are you talking about the grant to?
Well, what Your Honor is asking me is more with respect to the granting of summary judgment. The contractual indemnification clause is a broad clause which does not require negligence on the part of...
Right, I understand, but I wasn't sure which one. I was not asking about the indemnification at that point. But I felt like you were answering that. That's why I was trying to clarify which one you were answering or addressing.
I was addressing the fact that Just because there's a sign-off on a work done, that does not, it's not dispositive of the issue of negligence.
That's what I thought.
And
So I'm asking what else was necessary? You know, you're saying about the underlying work, but you were there the entire time. I think because this was some special protected roads that you had to be there the entire time the work was being done. So
well, there's no
what
evidence.
else was it for you to, what were you signing off if not for all the work that was done and the way it was done?
Well, there's no testimony, there's no evidence that Con Edison was present during the entire time of this project. Also, there's no testimony that Con Edison or the City of New York was present during this project. In fact, Stepmar's witness at his deposition said he did not recall this particular project.
Well, were these protected roads?
This particular road was a protected road, Your Honor.
And what does that mean?
Well,
as far as your responsibility or the city's responsibility for being present during the work?
Well, there is a requirement to be present. That does not mean that they were present or.
So they were required to be present, but they weren't present, but they signed off on the work that was done?
Well, Your Honor, this is a motion for summary judgment. There's got to be prima facie proof of entitlement, and there, as it's set forth, there is none.
Well, if their prima facie entitlement was that they did the work in 2009, you signed off on it in 2009. This accident happened in 2014, 5 years later, where roadway conditions can change. We know that Trimacine was responsible for the final cap-off, if you will, and the plaintiff's expert also points a finger as to the manner in which their work was done to potentially have caused infiltration, separate in the fact from the constant commercial traffic over that particular excavation point or that rectangle that we see in the roadway. So they met their burden, you know, in terms of the, where is your proof that as of 2009, the Stepmar's work as the subcontractor was defective to have been a competent producing cause of the 1 and 2 inch gap that caused the plaintiff to trip or 2014?
There's expert testimony that indicates that the depression in the roadway is because of the improper compaction.
Oh, did that expert see the roadway? If I'm not mistaken, the plaintiff's expert never saw anything. It was the defendant's expert that went there and evaluated the documents and actually went to the roadway site and saw what was needed to be seen. Am I correct, or did I miss that?
No, that's correct, but he saw pictures.
So that means the plaintiff expert is resting on speculation.
It's not on speculation. He's resting on his examination of the photographs and the records and the requirements from the City of New York. An expert can render an expert opinion on viewing photographs and other documentary evidence.
Okay, thank you. You have some rebuttal. I guess you'll address your indemnification issue then. Next up is, I'm sorry, who was it? The city. I'm plaintiff appellant. You're plaintiff appellant. Okay, then you should come up. I'm sorry. Thank you.
Good afternoon. May it please the court, Your Honors. Plaintiff appeals from the trial court order which granted Stepmar's summary judgment. That's a contractor that indisputably performed excavation in the crosswalk exactly where my client fell. There are two different kind of defects that contributed to this accident. One is the cracked condition of the roadway and then the depressed condition of the roadway. Now, it's our position that Stepmar did not meet its burden on summary judgment because its expert, I know you mentioned that their expert went to the site. Looking at his affidavit, the date he went to the site is not in there. I think it says 2018. There's no representation that when he even went to the site, it was the same as in the photos or as in the, at the time of the accident. There's no indication that his inspection in any way would make a difference. Our expert does opine based on photographs, the testimony, the DOT regulations and documents that have been produced in discovery. There is no compaction report produced by Stepmar. It's their burden to show that they did the work free of negligence, that they did not cause or create this condition. There's no dispute that they did the work in the area, that they cut the trench in the crosswalk, that they were required to backfill it, and that in connection with that backfilling, they were required by the DOT to do certain things like compact the backfill material. We have no testimony from anyone with personal knowledge of whether that was done. The missing compaction report only just raises further questions as to whether, if it was done properly and in accordance with the DOT guidelines.
Counsel, there is no dispute that Con Edison signed off on this work in 2009. True?
There's no dispute that Con Ed signed off on in 2009. There's no documents from the city.
And when we're going 5 years later, and I know it's not easy, 5 years later, for us to say that the subcontractor, Stepmar, did the work negligently, particularly when you've had, in the 5 ensuing years, blizzards and all kinds of conditions in the roadway and traffic with huge commercial vehicles driving over this crosswalk. We understand it takes its toll, as set forth in the defense experts' report. The alligator cracks, that's a unique word I had to look up. But in any event, so where is the evidence in opposing the Stepmar's summary judgment motion and supporting papers? Where's the evidence that establishes that the defect was in effect in 2009, that the work done was defective, to have been the contribution? I mean, how do you prove that 5 years later?
Well, our expert Farinick does address their argument that it's related to heavy traffic or other conditions. This particular depression is right where they cut their trench and did their excavation and backfill. It's not in the entire crosswalk. The crosswalk gets the same traffic. The other areas of the roadway and the crosswalk don't have this particular defect, which is the depression of I believe, 1.5 inches deep. Now, that depression is consistent with the faulty backfill that was performed by Stepmar. That would connect Stepmar's work to that depression specifically in the roadway. And the fact that 5 years had passed, that's not dispositive. I mean, there's cases where 7 years have passed, there's cases where 4+ years have passed.
Where there's been a sign-off as to the adequacy and of the work that was done when it was done?
Well, in Jones v. City of New York, in that first department case, it was only about a little over 3 years. It wasn't quite that, but there was a sign-off by Con Ed, and that was insufficient. The court found questions of fact were raised, drawing all reasonable inferences in favor of the non-moving party.
Was there any evidence that the defective condition existed at the time that Con Ed accepted the work?
Well, Mr. Farinick would testify that over time the depression would get deeper, but that it would be faulty right at the start. But as far as the depth of that depression, that could get worse over time based as the sub-base, because it was not properly compacted.
But Mr. Farinick also said that Trimacine didn't properly seal the work when it was completely level and flush with the roadway, as we understand it had to be, which would have allowed for water infiltration that could have impacted on the compact work done by Stepmar.
That's correct.
And while he has multiple ground to support the condition, when you have that theory coupled with the sign-off in 2009, where there's no evidence here that the work of the compaction was defective at that time, doesn't that suggest speculation on the part of the compact work not being done appropriately 5 years earlier?
Well, the affidavit, as far as the ceiling, I mean, that was not found to be speculative by the court. I mean, that was also an opinion five years
I'm
after.
not questioning that. I'm trying to understand, your principal appeal is challenging the grant of summary judgment of Stepmar.
Correct.
I get that.
Right.
And you meaningfully want to oppose summary judgment in the face of a sign-off 5 years before the accident. Like Con Ed, you want to oppose it. You want to say that the work was done negligently 5 years earlier.
Well, there's missing evidence as to what Con Ed was even approving at that particular point in time. We don't know if Con Ed even had a compaction report at any point. What they're actually approving. Are they approving the backfill material, that it was done according to DOT highway standards? Are they approving, I mean, these are questions of fact that they didn't eliminate in their initial motion papers. And the lack of the compaction report alone, I think they can't meet their burden without anyone with personal knowledge.
Thank you. You have rebuttal.
Good afternoon. May it please the court. My name is A.J. Smith. I represent the defendant Stepmar in this particular case. And I come here to say that the lower court got this right.
Counsel, the fact that the compaction report is not available, how does that affect your client?
The compaction report is one piece of evidence that would have helped us if we had it, but there's also two other references in the records that Con Ed produced that shows that the inspections that were necessary to get the compaction report were done. And in fact, in one of the records, it's noted, and I believe it's at page 1063 of the record, it's actually noted that the compaction report was issued. So in a perfect world, you know, would I like the compaction report? I love the compaction report. We don't have it. It's a shame. But the truth is, the record, I think it's Exhibit Y to my original motion, talks about the fact that the compaction report had to be done, and it was done, and it was issued. And the point being, the only people in the world that know what that looked like the day that we finished back in 2009, my client, Con Ed, who said it was done right, a representative from Exclusive Testing, who said it was done right, and representatives of the City of New York, who said it was done right. And then after this occurs, we retain an expert who goes to the site, and unlike plaintiff's expert 11 years later, does photographs, takes measurements, and makes notes about what he's seen and what he's located. He looks at all the measurements and all the rest of the stuff. To suggest that we haven't made out our prima facie case borders on the absurd. I don't know what else we can do at this point to make out a prima facie case. We have all the testimony from Con Ed, who to me it's almost comical that they come here and say that they're not sure whether this was done right, when they're the people that said it was done right. They're the very people that said it was done right. The City of New York said this thing was done right. The independent testing laboratory said this was done right. As the court has pointed out earlier in the questioning, the plaintiff's expert doesn't know, and nobody in this room knows what this place looked like in 2009.
Counsel, do you agree that under the agreement you have with Con Ed, that even if there was no negligence on your part, they still could have a basis for contractual indemnification?
The wording in these agreements is very, very important, Judge. And the wording in this agreement is arises out of our work. It came from our work. It's not in the scope of our work. It's not anything that happens on this project. Con Ed wrote the contract. We signed it. The contract has to be decided against the person, the drafter of the contract. Their contract says arises out of our work. The court has already said this didn't arise out of our work. They haven't made out a prima facie showing that it did. The court said the opposite, that it did not arise out of our work. And I submit to the court, Trimacine is still in this case.
Is it fair to interpret that as being connected with your work?
I'm sorry?
Is it fair to interpret that as being arise out of or connected with your work?
I don't think it's possibly fair to say that because if my work was done right, then this accident wasn't caused by my client. And no one has proven that they didn't do the job right.
So, but if it was, okay, I'll leave it at that.
Yeah, I mean, there's no other way of saying it. The other thing I would like to point out is counsel in his argument for Con Ed said something about it's not dispositive about the fact that they signed off on the work. The court below didn't even address this argument, but it's in our papers, and it was in our papers below. The accepted work doctrine in New York says the opposite of that. The accepted work doctrine in New York, which really isn't addressed by the lower court, says that if we do work for somebody and the contractor says that we've done it right, then we are not responsible to third parties. We're not responsible to injured people. The work that was done under the contract was accepted by the person who retained us to do it. And for 5 years later, we can't be called into court with no opportunity to fix it, no opportunity to go back, nobody mentioning us that we've done something wrong, and then say, now you're responsible for what you did. It's in our brief, but I will say it's not just that nobody said anything got done wrong. Con Ed at the time accepted that work, and that our tort liability is not universal to the entire world. Once our contract has been fulfilled under that doctrine, we're not responsible to third-party people like the plaintiff. And with that, I appreciate the court's time, and happy Thanksgiving to everyone.
Thank you. The same to you. And rebuttal, please, from the city.
Your Honors, with regard to the contractual indemnity cause of action, the contractual indemnity clause in this case does not require negligence on the part of Stepmar.
We got past that part, but we're onto the contract language. Counsel says, you know, it doesn't arise out of. The contract says, or connected with. Do you think that the work was connected with? He's saying there were facts here that demonstrated there was no connection. There was no arising out of. What do you have to say to that?
Well, in fact, under the decisional law of this court, that the contractual indemnity provision would apply in this case. The fact is that the plaintiff fell in a depression in an area where Stepmar performed work. To be liable under the indemnity provision, Stepmar does not have to, we do not have to show that Stepmar was negligent. In fact, the court's attention is drawn to the case of Fireman's Fund versus State National.
I'm not saying that you have to find that there was negligence here. I'm asking you specifically if you feel the work falls within the words that I just used, connected with or arising out of. Counsel says it doesn't.
Yes, and this court in State National under Fireman's Fund versus State National under similar circumstances found that it did. In that case, a contractor painted steps and was found not to be negligent, and the court found that that work, merely painting the steps and making it the same color as the rest of the walkway, although not negligent, was connected with the work of that particular subcontractor, and that's the case here too, Your Honors.
Thank you.
Thank you.
Counsel.
I just want to add that there isn't a document from the city approving this work. What their expert actually says is asking us to make assumptions based on the fact that the work continued. The city must have gone and seen it. In paragraph 15, he says it can be reasonably assumed. I mean, they're asking for us to make assumptions without evidence to show that, including the testing. All of this testimony was what should have happened, what could have happened, what should have happened, not what actually happened. And
Counsel, did Stepmar offer any evidence in admissible form indicating or suggesting that the work was approved by the city, by Con Ed, and that the work was not defective at that time?
not by the city. There's just this checkoff by Con Ed on a single form.
All right, so Con Ed we have, all right.
But there's nothing from the city to show that they approved this work after it was done, other than they say the fact that the work continued, we can assume that it was approved because they wouldn't have allowed it to continue if it wasn't.
Was the city's approval important here, though, or Con Ed, since Con Ed was the contractor who hired Stepmar?
Well, as in the earlier discussions, we talked about the protected streets and that, you know, the city would be there every step of the way and Con Ed would be there every step of the way, but we don't actually have any evidence that Con Ed was there every step of the way. We don't have any evidence that the city was there every step of the way. We're missing various pieces of evidence here, aside from the compaction report, including, you know, anyone who actually did the work on the site or the testing that they say they had done by the third party. I mean, these are things that aren't submitted in his expert report and or affidavit. He's asking that assumptions be made based on the documents that have been produced related to the work.
Thank you.
Okay.
Thank you all. People versus Quran Lassiter.
Good afternoon, Your Honors. Nathan Brown for Appellant Karan Lassiter. Mr. Lassiter's sentence was excessive in light of his young age, his sincere remorse, and the disparity between his sentence and those of his co-defendants. Mr. Lassiter was only 15 years old when the events of the indictment commenced, and a 15-year-old, as the research has shown, have the characteristics of a developing brain that make them more vulnerable to their environment, more susceptible to negative influences, and generally more impulsive and reckless. And for these reasons,
This is a 15-year. I mean, it's tragic. It's tragic for him. It's tragic for the officer who lost his life. But this is a 15-year-old who, by the time he was pled guilty on this offense, I believe he already had 6 YO adjudications. Is that right?
he did, Your Honor. He received time served or conditional discharge for those 6 misdemeanors.
And then, in addition, he was sentenced 2 to 6 and 7.5 concurrent, and that was to run concurrent with a pending weapons, gun possession case. So there was a lot in his history. So I guess my question is, I understand what you're asking, but how can we be certain that a reduction here is going to make a significant difference? And what reduction would you be asking?
Certainly, Your Honor. I think to the earlier portion of your question, I don't think that some of those facts that you laid out explain the disparity between some of his co-defendants. For example, one of the co-defendants, Defendant Wigfall, was convicted of the exact same charges as Mr. Lassiter. And if we assume that Mr. Wigfall did not have any prior convictions, we would have to explain a 4-year disparity between their sentence when we're talking about misdemeanors for which Mr. Lassiter was convicted of conditional discharge or time served, which seems excessive to me. As far as your second question, I think a sentence in line with his co-defendants, such as 5 years like the defense counsel at the trial had requested, would seem more in line with the sentences his co-defendants received and the fairness that would go along with that. I can highlight
5 years. Are you saying 5 years on the second charge? I think that is on the conspiracy, attempted gang assault. Is that what you're saying?
Yes, I guess it would also involve reducing the 2 to 6 to 2 to 5, or such that his aggregate would be 5 years, in the same way that Defendant Inyama, who also was convicted of second-degree attempted murder, received 5 years. So I think in looking at the different sentences, a 5-year sentence like defense counsel had asked for is a more fair sentence given Mr. Lassiter's conduct here.
Did you have a question?
If no other questions, I can reserve for rebuttal. Thank you.
Just let me ask you, do you want to tell us anything about his family or anybody else who will be supporting him, or whether he has such supports or anything else?
Certainly, Your Honor. He's out now. You know, he's working. He's living, I believe, with his sister. She's been supporting him. She's been working with me and helping to support him. And he's been doing great since he got out, and I believe it was May. So, you know, I think that bears on the rehabilitation that he has gone through, and bears on the research on the youth brain development, which, you know, sort of his life speaks to as he was caught up in these things without the ability to make mature or responsible decisions. And now that he has gained some maturity and age, he's doing you know, fine. He's working and living a responsible life.
Counsel, just so that I'm clear, you're asking for a reduction in the post-release supervision? Is that where you're at? Because he's out, right?
Right. It would effectively reduce the post-release supervision if the sentence of imprisonment is released, because it would just
Right.
sort of.
When is that scheduled to end, the post-release supervision?
I don't have the exact date. I believe.
Isn't it sometime early next year?
I believe that is the date.
And is he a potential beneficiary under the Less is More Act?
He certainly is, but, you know, less is more is not designed to address an excessive sentence or an unfair sentence. It's its own mechanism to address the effects of post-release supervision and other post-release situations.
Has he received any benefits? Any? I mean, I know you can receive 30 days off of, or I might be quoting it wrong, but has he received the benefit of the less is more thus far? Since
the last I spoke with him, I haven't seen. You know, they get the sort of report on where they stand after the less is more calculation, and I haven't seen his recent report, but I believe that it should be credited to him after that threshold was reached.
Thank you.
Thank you.
May it please the court, Emily Gold on behalf of the people. To address your last question, as of October, defendant has received 5 months of earned time credit. There's no reason to reduce his sentence. The only reduction would go to his time on supervision, and if he continues to comply with supervision and follow the law, his period will be reduced to the statutory minimum of 2.5 years under the Less is More Act. And given the serious nature of the crimes—
Counsel, how do you respond to your adversary's argument that the defendant's sentence here was excessive in light of what the co-defendant's sentences were?
So there's several reasons and several things that go into consideration when sentencing a defendant, and they really weren't so different than what defendant received. In fact, 2 defendants, Tajon Terry, he was convicted of second-degree conspiracy. He got 6 to 18 years. Taekwon Comicio was convicted of second-degree conspiracy, second-degree criminal possession of a weapon, got 3 to 9 years, and then 10 years. It was remanded for a YO sentencing. And then he received 2 to 6 years, and then 8 years plus 5 years of post-release supervision. The co-defendants that defendant references in his brief, they got 3.5 plus 3 years, 1 to 4, 5 years. Well, we don't know what their criminal history was.
How about Wigfall in particular?
Wigfall got 3.5 years, and then 3 years of post-release supervision. He was convicted of second-degree conspiracy, first-degree attempted gang assault. That's not so different from what defendant got. You know, defendant didn't get 15 years. The maximum, he was facing 8 to 25 years on the conspiracy, and then up to 15 years on the gang assault. And as your honors have pointed out, he had 6 youthful offender adjudications, he had a prior felony conviction, and this sentence was running nunc-pro-tunc to a 2015 felony conviction. So he got 2 years taken off or credited for right off the back. So given all of that, defendant's sentence was fair and it should not be reduced on appeal.
Counsel, you're not, with regards to the waiver of right to appeal, you're not... We're
not taking a position on that. We're not contesting it, no. So
That's a good idea, given this waiver. Yes. Maybe DA's office can do something when they're in court and they hear waivers that are so poorly articulated. I don't think it helps anybody to have them like this. Anyway, thank you.
Thank you.
Your Honors, I'll just quickly highlight the co-defendants that my friend highlighted as well, who got more serious sentences. They are not similarly situated to Mr. Lassiter. For example, defendant Terry was not a minor, so you know his sentence would not fall into the minor circumstances. Defendant Camiso, he was resentenced to a YO, but his sentence ran concurrent to 3 felony offenses, including the instant offense. The other 2 were 2B violent felony robberies. So I don't think that those are comparable co-defendants when we want to look at the justice of the sentences in comparison
Sir, I
to
mean,
one
it's
another.
particularly in a conspiracy, every individual is going to play a particular and unique role within that conspiracy. Each individual comes with his or her own criminal record or experiences or history or family support. Is it really fair for us, vis-a-vis the trial judge, to exquisitely fine-tune these sentences among co-defendants?
I mean, it's something this court has done in the past when reducing sentences. So I think that it's a consideration. I think in looking at some of these co-defendants, there are it's difficult to explain such a wide range in sentences when we're talking about the same or similar conduct. I know my time is up, but very quickly the prosecution highlighted the number of counts and overt acts that the individuals had. But when you actually look at those numbers, they're remarkably similar for 85-page indictment with hundreds of counts. I think there was a difference of 2 numbers of counts across the defendants we highlighted. So I don't think it comes out to a very different set of conduct, but the sentences ended up being very different. Thank you.
Thank you. Thank you both. Burgess versus Avignon Taxi.
For the plaintiff appellants, Jay Breakstone, I thank the court for the 2 minutes. I know it's a busy day, but I wanted to highlight 2 matters and bring it to the court's attention. There are 2 orders here. As to the first order, which granted summary judgment and did it basically only on defendant's doctor's report, I would like the court, when they take a look at this, to note that the examination was 2 years after the hit-in-the-rear accident that caused the injury. It did not deal with the 9180. It did not make a determination as to causation, and it was based, as I said, solely on Dr. Kudladny's report. And he limited his report to present time only, and that phrase is on page 75 of the record. Then when we come to order number 2, at that point, the plaintiff's attorneys realized that the doctor's report that they had sent in, which, in all honesty, I think the record shows was done by a first-year associate who didn't know any better, which is not an excuse, but it seems to be rather common, neglected to understand that 2106 doesn't recognize chiropractors as doctors, or those doctors that can merely sign their name as to truth or veracity, and it has to be done in an affidavit form by a notary public. Once that was realized, that was corrected, as the case is cited, I think, at page 24 of my brief, had been done in the past. And now you have a report that lists significant defects in the cervical and lumbar spine, defects that in 2011 were significant, and even in 2015, I think is the date of the year of the second examination, were even more significant. They're marked defects, and the defendants either didn't have the opportunity, as one way to look at it, or didn't have the evidence to counter those arguments. And of course, when you have doctors disagreeing, lo and behold, you have an issue of fact. And only juries can decide that, not judges. Before I wrap up, let me tell you that the judge, the Supreme Court judge, the motion court judge, on the motion to renew and re-argue, even though he denied it, he actually read the material and relied on the material, which his decision shows that he did, and therefore the motion is appealable to this court. I think that issue might have been raised by my adversaries, but I think the court is well aware of what happens in these situations as a practical matter, and even though the statute was changed a while back to require separate rulings on separate horns, if that's the word, of the motion to renew and re-argue, it's possibly a rule that's most violated in the breach, and it makes it difficult for us on this end. If there are no other questions, Your Honors, I bid you a good afternoon.
Thank you. FPG Maiden Lane versus Bank Leumi USA.
May it please the court, good afternoon. My name is Stephen Mandelsberg. I am the attorney for Appellants Bank Leumi USA and 3 other lender parties in this appeal. Every once in a while, a decision is authored by a trial judge that is so off the mark that one might reasonably conclude that it's divorced from all commercial realities in a way that's truly detrimental to the reputation of New York as a global commercial and business litigation center.
Okay, counsel, let me just narrow you. I want to just narrow you down a little bit.
Sure.
There are a number of claims made here. What about the breach of contract claim that the plaintiff has? Is there no breach of contract claim here where he alleges that the lenders agreed to provide funding before the deadline of the temporary certificate of occupancy and then they stopped the funding before?
No, Your Honor.
Okay.
There is
Tell
no
us
breach
why
of
not.
contract claim because the breach, the alleged breach in this case, is precisely that the lender parties, my clients, had the right or went about denying requests for funding, which they had a right to do because of the existing default. The complaint in this case acknowledges repeatedly that this project, this 58-story South Street Seaport project downtown, which was perpetually plagued by delays since it started, since the loan documents were entered into in 2015, that this project was perpetually characterized by delays that had nothing to do with my clients. Leaning of the tower 3 inches to the north, construction worker falling off of a scaffold, overruns, replacement of the general contractor. All of these things were the reason why this project was in such terrible disarray. So the breach of contract claim, Your Honor, is basically a claim that's alleging that my clients breached because they refused to provide funding that they had a right to decline under the terms of the loan agreements. There are at least 5 reasons why this lender liability complaint
Except with regard to the Third Amendment. Wasn't the Third Amendment done because there were already so many issues before with them not being able to pay? And so they had the Third Amendment where now they had to put up a significant amount of money. And I thought in that Third Amendment that the lenders would be required to fund the loan proceeds even if there was a budget overrun in a particular
No, Your Honor. The lenders were
category.
required to fund the loan under certain conditions. And the section that they cite in their complaint conveniently omits the last part of the document, which says that should there not be an event of default. In other words, the funding here was conditioned upon an absence of default. It was conditioned upon the fact that they would be able to meet this temporary certificate of occupancy deadline. Remember, this was a project that started in 2015, so there were 2 other extensions which my clients granted. And this Third Amendment was supposed to be the one in which the developer here promised to get this done by certain dates. Otherwise, what you would have here is a situation in which the lenders are what? Required to fund forever, required to fund perpetually. And, Your Honor, I know, having sat on the appellate division panel that issued the Centra case, you're very familiar with that decision. That decision, as affirmed by the Court of Appeals, upheld a release that is not even as broad as the release we have in Section 14 of the Third Amendment. The lower court misinterpreted that Centro decision by injecting magic words that the lower court believed had to have been in the release. It should have said fraud. It should have said known or contingent. But actually, the release in this case is extremely broad. As reproduced in the record at Record 202, it releases any and all claims of any kind of nature. And it not only releases general claims, it releases specifically lender liability claims, which this court and other courts have interpreted to include the very type of breach of commitment to fund claims that we have here. And in addition, the release goes on to say that to the extent there is any claim, it is finally, unconditionally, and irrevocably released, waived, and discharged. The Centro Court of Appeals decision and this court's decision, in which Your Honor, Justice Renwick concurred, mandate that this release be enforced. But it's not only the release that mandates dismissal of the complaint. It's the fact that they failed to allege justifiable reliance. This court has repeatedly dismissed claims for fraudulent inducement where there's no justifiable reliance alleged. For example, there is, Justice Renwick, your opinion in 2017 in Fed Mogul Corp. UTI, 45 New York 7th, 3rd 40. Justice Higgett earlier this year in Gertzog v. Goldfarb.
Just to be clear, your time is up, but just to be clear, the fraud, I was speaking about the breach of contract claim, not the fraud claim. And so you were talking about Centro, which was with regard to the fraud claim. But anyway, thank you very much. You have
Thank you, Your Honor.
Rebuttal.
Good afternoon, Your Honor. Let me start with the with the breach of contract claim, because the complaint does indeed state a straightforward breach of contract claim. The complaint alleges that there were 3 requests for advances that were due to be paid, that all of those were not paid before the event of default was cited by the lenders. So the loan agreement amendments were signed in March. There were funding requests for February, March, and April. The complaint specifically says that they were submitted to them before June 2020. That's when the event of default took place. I mean, it's a really very simple, straightforward breach of contract claim. There are additional allegations about bad faith in terms of the way the lenders handled the budget overruns and invoking the theory that one budget overrun excused them from making any advances. But that's the breach of contract claim, and Justice Ostriger was correct in upholding the claim. Let me turn to Section 14, which is the defense to the fraud claim. Section 14 is in the 3rd amendment, and it's, I think it's important to understand what Justice Ostriger ruled here at the pleading stage, which is simply that this particular clause did not utterly refute the fraudulent inducement claim. And he did that for a couple of reasons. The most important one is if you look at the language of the clause, it says as of the amendment date. So on its face, it's unclear whether this is cutting off claims under the original loan agreement, Amendment Number 1, Amendment Number 2, that existed as of the amendment date, or whether it's, as they claim, a get-out-of-jail card so that once you sign it, you're releasing all those claims. That's an issue that Justice Ostriger is reserved on. The other is, was it intended to include unknown claims? And Justice Ostriger observed that Centro Impresario sets a very high bar, and this language doesn't quite get there, at least on the motion to dismiss stage. There's no reference to unknown claims, there's no reference to contingent or future claims, and the all manner of claims language which was there isn't present. So Section 14, Justice Ostriger properly reserved decision on, upheld the claim, and allowed discovery to proceed, which, by the way, is essentially over at this point other than expert discovery. As for the justifiable reliance, which was not raised below, was raised for the first time on appeal, the complaint fraud claim pleads justifiable reliance very clearly. The Bank here, Bank Leumi, wore the hat of lender as well as administrator. And when the plaintiffs dealt with the administrator told them that the TCO deadline, which everybody knew was very aggressive, that they would handle it as they had in the past. They had a course of dealing over several years, and the plaintiffs relied upon those assurances from...
How can that be, how can the plaintiff have reasonably relied upon those assurances when the contract has explicit language to the contrary?
Well, the contract language, this is an interim deadline, Your Honor, and the contract does not have a reliance clause or a merger clause. So what they were dealing with was the loan administrator who told them, this is a clause that's in there, but I've worked with you in the past. I've extended this particular deadline in the past, and I will be working with you in the future, and I know it's aggressive, but you don't have to worry about it. Give me your $20 million, and we'll proceed. And that, I submit, Your Honor, is reasonable, and the court has, and cases are cited in our brief, the Davidson case in particular, acknowledged that statements that are outside the contract regarding performance, if made with a fraudulent intent, a present fraudulent intent, can give rise to a fraudulent inducement claim, and those are the facts that we have here. The other contract clauses...
Sorry, sir, your position is Section 17 of the Third Amendment wouldn't bar your fraud claims?
Section 14 of the Third Amendment does not bar the fraud claim, Your Honor.
What about Section 17, which I think is Justice Rodriguez was touching on, deals with the justifiable reliance element of
Section 17 is the TCO deadline, Your Honor, and that does not bar the fraud claim, Your Honor, for the reasons that I explained and which Justice Osterger recognizes valid, mainly that the contract doesn't have a merger clause, doesn't have a no reliance clause, and that we're dealing with a loan administrator and a course of dealing that we've had for years. So this is a whole variety of factors that are, I would say, unique to this case. It's not a threat to the commercial establishment of law in New York as the lenders claim. But if you're dealing with a loan administrator for years and the loan administrator has in the past extended and used its discretion in a particular fashion, and it tells you that's what it's going to do in order to get $20 million from you, I believe that constitutes justifiable reliance, notwithstanding the language in the agreement. I'm through, Your Honor. If you have any questions, I'd be glad to answer them.
Thank you.
I ask the court to affirm. Thank you.
There are just a few points. First of all, the contract claim. The complaint in this case acknowledges that the request for advances were made after the date of the Third Amendment. The Third Amendment was entered into as of March 13th, 2020. The requests for advances, which were for a few $1 million, were made after that date. So you can't have a breach of contract claim for something that breaches the Third Amendment when it was after that, when they already breached the Third Amendment. As for the fraudulent inducement claim, let's understand what their fraudulent inducement claim is. It's that despite the agreement that they made in the Third Amendment to abide by certain deadlines, despite their agreement that the conditions of funding were stated, there was an oral agreement that they would be ignored. This directly negates the very point of the release, and it also negates the no oral modification clause in the contract. I believe, Justice Shulman, you authored a decision on this that upheld the rule that no oral modification clauses mean that you can't orally modify an agreement that provides for certain terms. As for the claims for justifiable reliance, they must, in order to establish a claim for fraud, any claim for fraud, establish justifiable reliance. The precedent in this case, the precedent in New York, is absolutely pellucid, that you can't justifiably rely on something that is directly contradicted by the agreements that you sign. And finally, Your Honor.
Sir, what section of the amended agreement, Third Amendment agreement, would undercut fatally the justifiable reliance?
The provisions that state that they must provide a TCO by May 30, may I continue? Yes. May 30, 2020. The provisions that say that they must complete the project by a certain date. the provisions that keep a loan maturity date of 12/31/20. And finally, Your Honors, there's been no allegations whatsoever to support personal jurisdiction over the foreign defendants. Even the lower court acknowledged that he was skeptical, that the judge was skeptical of jurisdiction. They have not pled any alter ego theory. These foreign affiliates have no connection whatsoever to New York. And there's no agency or other theory piercing the corporate veil alter ego theory that's pled in the complaint. So for these reasons, we think the lender liability complaint should be dismissed in its entirety. Thank you for your time, and I wish you all a happy and healthy Thanksgiving.
Thank you very much. Thank you both, and the very same to you. Wolf versus Bloomberg.
Good afternoon, Your Honors.
Good afternoon.
May it please the Court. Can everyone hear me?
Yes.
Okay, excellent. So this appeal raises a very fundamental, important issue, which is the difference between the New York City human rights law and its federal counterparts, specifically in this case, the ADA. Contrary to my opponent's briefing, these are not mere nuances. These are fundamental differences, critically important. And with respect, the trial court's ruling fudged those differences and piggybacked off of federal court's interpretation of the ADA. Even if the New York City human rights law generally may be said to track the ADA or have some similar elements, that's not the same thing as having the same standards. And this was actually emphasized by the Court of Appeals fairly recently in 2021 in a case brought by Bloomberg, or against Bloomberg, Doe v. Bloomberg, cited in our brief. So with that in mind, firstly, plaintiff was clearly disabled under the city human rights law. Under the city law, and actually under the state law too, any impairment can count as a disability. He was clearly impaired. Disability is not defined on whether you can reasonably be accommodated and perform your job. It's not accommodated under a major life activity. It's not defined by anything other than an impairment.
What did plaintiff have to demonstrate to receive, for his state claim to survive?
That he was impaired in any physical or mental way.
And what did Bloomberg have to do?
They would have to show he had no impairment, presumably.
Don't they have to provide reasonable accommodations?
I'm coming to that next, Your Honor. The threshold issue is, was he impaired?
Yes, okay, I'm moving along, trying to move us along. You only have a limited amount of time, but go ahead.
I get that. So given that he was impaired, he did mention this, he did raise this before defendants. Once he did so, it was their burden, not his burden, their burden to accommodate him and to engage in an interactive dialogue towards accommodating him. They did not do so. It is the employer's burden under the city human rights law to show that the unavailability of safe and reasonable accommodations that put no hardship on its business. They did not do that. And that is, by the way, the Jacobson case cited in our brief, the 2014 Court of Appeals case. Once plaintiff told them he was disabled, it was their burden.
At the end of the day, putting aside whether you think it's nuances in terms of how one interprets the ADA versus the city HRL, we're left with your client's own admission that putting aside whether he wouldn't get migraines in Singapore or Hong Kong or in the Asian theater of what he does, and at the end he said basically just change my supervisor, which they did. Point one. Point two, you do not dispute that anytime he sought leave under the Family Leave Act, that Bloomberg was extremely accommodating. for the various reasons, for his heart surgery, to take care of family. They were very liberal about accommodating him and understanding and sensitive to his migraine condition. You don't dispute that, do you?
I respectfully would. I don't dispute that they offered him leave. I respectfully dispute whether that counts as a reasonable accommodation or an interactive dialogue.
But my point is that at the end, even though he discussed, he presented about, I think, 9 options, 9 potential work sites or areas, and he reduced it to 2. There was a discussion with him and his management where it's really unclear whether he was overqualified for one, underqualified for the other, but essentially it would not necessarily resolve his migraine issues, so that ultimately your client, under sworn testimony, basically said, just change my supervisor, and it went from Mr. Bowser to Ms. Brown, correct?
Okay. He changed supervisors several times, and it did not resolve his migraine issue. And his neurologist specifically said, this is not solvable with leave. So there's something more was needed. At the very least, a dialogue about that was needed, and that was not offered. There was leave, take it, or, pardon the expression, leave it. There was no other alternative offered or accepted. He was rejected every time he proposed something. So I don't see how that's an interactive dialogue or a reasonable accommodation, Your Honor.
Good afternoon. May it please the court, David Garland on behalf of the respondents. I recognize we do have very limited time, so I think it makes sense for me to start responding to some of the dialogue that you just had with appellant's counsel. Starting with the questioning around the distinction between, the ADA and the city law. And what I didn't hear in any of that discussion was the doctrine of collateral estoppel. And that's what this case is about. I mean, there's a long line of cases in which I think at least 3 of the 4 panel members I've identified as having concurred in cases applying the collateral estoppel doctrine to circumstances similar to this. And Justice Renwick in the Simmons-Grant case, which I think is probably cited as often as any collateral estoppel case, you concurred in the opinion addressing the distinction between the ADA and the city human rights law. And the court in that case said, while recognizing that the city human rights law must be construed liberally to accomplish its purpose, that principle does not substitute for evidence. And Justice Shulman, to your questioning, there is so much evidence in that federal record in terms of what happened, in terms of the history and the dialogue and the reasonable accommodations that Bloomberg did in fact offer. In the record established that
if a reasonable accommodation is discussed and provided, does it have to be the one that the individual comes up with, or can it be a different reasonable accommodation?
Yeah, absolutely. It doesn't have to be the one that the individual proposes. We go back to the Pimentel case here that this court decided, I think it was in 2006. In that case, the accommodation the plaintiff sought was to go to a job that didn't have any contact with individuals, with persons. Well, the employer in that case couldn't provide it. And so the accommodation proposed by the individual was inherently unreasonable. In this case, again, the record is well established in the federal decisions. The plaintiff here, Mr. Wolf, wasn't even eligible for a transfer because he was not in good standing. And the only accommodation request that he made was, I want a new supervisor. I want to be in a different position with a different supervisor. And to take the logic of the argument that the appellant advances here is that if an individual employee finds his or her position stressful and attributes headaches
to that workplace stress and demands, requests a new supervisor, then the employer must provide the new supervisor to that individual. And that could be repeated again and again. And it might not just be the one individual making those requests, it could be multiple individuals in the workplace making that request at the same time, which I would submit would produce anarchy, which I think is why the trial court rightly said that, yes, we take into account that the city law has a different standard than the ADA, but the bar proposed by the plaintiff in this case was so low as to be inconceivable that the legislature could have contemplated that.
Sir, how do you answer your friend's point that Bloomberg did not engage in a good faith interactive process to arrive at a reasonable accommodation?
I would answer that with the question that Justice Schulman asked, which was, isn't it a fact that on numerous occasions, Mr. Wolf was granted leave? I think no fewer than 3. The Bloomberg suggested to Mr. Wolf that he should take intermittent leave. Bloomberg encouraged Mr. Wolf to take time to take care of himself. Again, that is all in the very, very well developed record. And then with respect to the retaliation claims or the discharge claims, again, the courts, in the district court, the Second Circuit decisions, and there are 2 Second Circuit decisions, all point out that Mr. Wolf came forward with no evidence to challenge the legitimacy of the business decision made by Bloomberg here, because the performance issues that ultimately form the basis of the discharge decision predated his raising any issue with a supposed disability. So I thank you for your time and ask you to affirm.
Thank you.
Thank you, Your Honors. My time is limited. I do want to jump on a few things that were covered here. Overall, collateral estoppel, as noted in our brief, is inapplicable when the fundamental legal standards differ. Here they did not. Here they did, excuse me.
But it didn't go to the legal standard. It went to the facts. It went to establishing the facts.
I'm not sure I agree with that, Your Honor. For example, first of all, the trial court did not apply the city.
The legal standards between the state and the city are different than the federal standards. There's no question.
Right.
But the state and the city standards were applied here using the facts that were established in the city. In the federal actions.
Certain facts were established, Your Honor, but I don't think there's any dispute the fact that, for example, my client's neurologist said he cannot be accommodated simply with leave, and no other alternative was ever raised or considered, for example. Wolf's request is not only a different supervisor. He said different offices. And our brief notes, there are other options had they engaged in a dialogue that were possible. They could have.
Whose burden was it to demonstrate that there were available positions?
Theirs, under the city law, Your Honor. That's a key difference between the city law and the ADA. It's their burden under the city law to demonstrate that there's no possible alternative positions. So again, they say he was granted leave, but that begs the question. His doctor said leave is not going to suit him.
The burdens are different under the ADA and the state on the one hand and the city on the other. Is the meaning of reasonable accommodations different under the different regiments?
I would say not when it comes down to it, but I think the burden of proving that there's no alternative accommodation available is a critical difference.
But if there's factual findings in the federal action that reasonable accommodations were explored, and the federal court was satisfied that they were, and there's no difference in the meaning of reasonable accommodations in the federal context and the city context, why would there be a hindrance to applying collateral estoppel?
Your Honor, I'm not certain that it's the same standard, actually, now that I think about it. So I will leave it at that.
Thank you. Thank you both. Luo Associates versus NYIS Law Firm.
Thank you, and may it please the court. My name is Jeremy Sachs, appearing on behalf of appellants. The first question before the court concerns the application of New York's fair report privilege to the online attack ads that respondent posted about appellants on Google. The ads concerned a separate action that was filed in California in which Luo and Associates was sued by a former client for posting that client's image on the firm's website and stating that he was a satisfied client, when in fact his visa application had been rejected. Now, critically, none of the claims or the allegations in that action in California had anything to do with attorney licensing, attorney ethics, attorney suspension or disbarment, or even malpractice. The case was totally devoid of those topics. The claims in California were for misappropriation of likeness, 2 California Civil Code violations, one for non-consensual use of name and likeness, and the other for violation of a statutory unfair competition provision, and then a claim styled as, quote, fraud, intentional misrepresentation, end quote. Now, contrast this with the ads. There's 3 ads in question, and they are all very short and to the point. Each one consists of a link, a headline, and then a single sentence, or in one of the cases of the ads, a sentence and then another sentence fragment. And what each of these ads says is that Luo and Associates is, quote, facing a license suspension, end quote, as a result of the action in California. And one of the ads further states that Luo and Associates may lose its license. And so it makes this same point twice. Now that was completely untrue, and it's untrue objectively. And if one was to follow the links in these ads, they link to a separate third-party news article, and that separate article also says nothing whatsoever about a license suspension in the California action. And here's where we get to the crux of the issue, because while the lower court acknowledged that these statements about a license suspension were not true, it held in dismissing the complaint that the ads can't be dissected with a lexicographer's precision. In other words, that this statement was false, but the ads remained substantially true. And we submit respectfully that this was error. The test in this department for substantial truth under the fair report privilege is a nearly 100-year-old test. And the test is whether these ads would have a different effect on the reader's mind than the actual truth. And the motion court never raised that standard, never applied that standard, and critically, it never accorded appellants the benefit of every favorable inference on the point, which is what they are entitled to on a motion to dismiss. They are entitled to every favorable inference as to whether facing a license suspension had a different effect on the reader's mind than the actual truth about that action in California. And when you step back and you look at these ads, what they're really saying is, watch out. This firm's own client sued it, and in addition, it may be suspended from practicing law as a result of that lawsuit.
Also, here, at some point, there was a complaint filed with the Attorney Grievance Committee.
That is correct, Your Honor.
Where presumably suspension could have been a possible outcome. How does that affect your position?
So this was a critical factual error by the motion court, Your Honor, and the reason it was a factual error is that that grievance is evidenced by one single grievance letter, which is dated April 27th, 2021. That's approximately 2 months after the ads in question ran in February of 2021, and there is absolutely no evidence on the record that this grievance was filed or pending at the time that the ads were run. And the motion court expressly relied upon this in its holding and said the ads were run on the basis of this, that the grievance was a basis for the ads being true, when in fact it was not actually evidence that it was filed. I want to just briefly touch on the fact that the ads also do not report on this grievance. So there's no way for a reader to determine in viewing these ads that there's actually a grievance pending. Whether or not it was pending is not evidenced by the record, but this grievance was a confidential, sealed proceeding, and the ads plainly report only on the California proceeding. So the fair report privilege only protects the reporting about that California proceeding, and respondent cannot piggyback on another undisclosed proceeding, the grievance proceeding here in New York, whether or not it was filed, in order to say that perhaps these statements could have been true. I think I would like to reserve the balance of my time in rebuttal to address a point that I think is going to run over. Thank you.
May it please the court, Matthew Flanagan for the respondent. The argument was just made, and it was made in the motion court as well, that the complaint filed in California did not raise any attorney ethic issues. And I think it was said that there were absolutely no ethical issues raised by the complaint filed in California. The complaint is part of the record. The lower court relied on it heavily. It's at page 60 of the record. And what this individual, who's the plaintiff's former client, claimed was that he went in, he didn't go to a modeling agency, he went to a law firm, and yet they pressured him to take pictures with their advertisements. He didn't want to use his face because he probably is not here legally or was not at the time, and so they later on pressured him to use his face in these advertisements. And what did they do in those advertisements? And this is all clearly laid out in that California complaint. What did they do? They alleged, they set forth in their advertisement that they helped this man get a visa. He didn't get a visa. They said that they hired a consultant to help him and to support in support of his application. That wasn't true either. So these are all allegations against plaintiff, and to say it doesn't involve attorney ethics is just kind of...
But maybe if the word ethics, maybe if it was left sort of broadly that there was an ethical issue, but it was a little more specific, right? The ads talked about, or the banners to the ads talked about facing a license suspension, something more concrete and firm.
That was referenced in the ad, and it was stated, but for the, I'd say 90% of those ads just refer to the allegations in the California lawsuit, and my clients were entitled to report on that, and they're protected under Section 74.
But is that aspect of the reporting, the little synopsis, the little banner they include in the ad, that they were facing, plaintiff's firm was facing a license suspension, was that substantially true or substantially accurate for Section 74 purposes?
The article as a whole was substantially accurate. That was a prediction of a future event that did not come to be, but could very well have.
Just let me understand.
Sure.
You are representing a law firm.
Correct.
And your law firm was running an ad.
Correct.
For their law firm.
Correct.
To show how much better a law firm they were than the Liu law firm.
Well, they were running an ad which was critical of a competitor.
Something there sounds like it's not in compliance with the rules anyway.
It is, Your Honor. They are still entitled to the protection under the Civil Rights Act, Section 74, and that's not disputed at all. It was not disputed in the lower court, not disputed in this court.
Anyway, I digress, as they say. Why don't you continue with your answer to Judge Higgitt's question?
Sure. So the allegations in the complaint, and as we all know, a grievance committee can pick up an investigation from any place.
Yes, they can.
They can be referred by the court. They can pick it up from a newspaper article. The rules that were potentially violated, false advertising, Rule 7.1 of the Rules of Professional Conduct. They had an advertisement that had something that was not true, and there's no dispute that it wasn't true. They've never denied that. 8.4, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Again, clearly alleged in that California action. I think the judge in the motion court said, 20 times they mentioned fraud in that complaint. 20 times, not my client, it was the complaint, it was the plaintiff's former client who was making these allegations. Rule 8.4 of the Rules of Professional Conduct, pressuring this individual to take pictures. He's there, again, he's there to get a visa. He's not there to sign up for a modeling agency. He's there to get a visa, and they're pressuring him to take pictures. There was a grievance, as we heard, filed. It was dismissed.
The question, again, is with regard to the language that you used. Not about all the pictures and everything, but the way you spoke about it in terms of as my colleague said, facing suspension of its license.
Which is a possibility. If you have a complaint alleging this much misconduct, Rule 4.1 is another one that was allegedly violated. Rule 1.6, they referenced attorney-client confidences that were also violated. This is, again, not my client. This is the plaintiff's former client who claimed he was oppressed, abused, lied to, and then they went on and lied to everybody in their advertisements. So, these are all things which are violations of the Rules of Professional Conduct. If you assume, and if I could just finish this thought and then I'll rest, These are all things which could be deemed violations of the rules of professional conduct, which can and should lead to an attorney possibly losing his or her license, or a professional corporation losing the license to practice.
Thank you.
Thank you.
I do have one point. Wouldn't it have been simpler just to make contact the attorney grievance and provide that ad that you're talking about?
Well,
rather than the attorneys for that law firm running this whole ad themselves?
Well, it wasn't, my clients were not the ones who brought the
No, I
California
understand that.
action.
Your clients are the ones who published this information.
Correct.
Yeah, thank you.
And our position is it was substantially accurate, and also the attorneys.
I understand.
and the
You
attorneys for
answered it.
the- Okay.
Thank you.
Thank you, Your Honor.
Thank you. I want to just sort of recharacterize what I think respondent is saying here with respect to this California action. What respondent is saying is that the California action is about attorney ethics because it is about attorneys, and that, in other words, any action that involves an attorney is automatically about attorney ethics. And not only is that not the standard, that is the opposite of the standard as expressed in cases in our papers. If there is a fair and true report of a judicial or quasi-judicial proceeding, statements about that action may be protected. If they go beyond the action, they are no longer reporting on the action. The fair report privilege is not available.
And the standard, though, it's not pristine accuracy, it's substantially accurate.
That's correct.
And so in the context of the entire ad, and I realize entire, it's a relatively small ad, but in the context of that entire ad, was the entire ad substantially accurate?
It was not, because this phrase that appears in each ad about a license suspension fundamentally changes the meaning of the ads. What it's saying is, you, potential client who's out there searching for a law firm who's going to shepherd you through this United States visa process, this lengthy and involved process, this firm that you're considering hiring may not be around long enough to actually get you through the end of the process. That the firm may be disbarred, the firm may be suspended, and these are non-English speakers, these are non-native individuals seeking immigration into the U.S., and they're seeking an attorney. And they don't have any basis to understand the context or the action in California, and what they're seeing is this firm may be suspended. To the extent I have time, I want to just touch on the motion court's other basis for dismissing this action, which was the fact versus opinion basis as it pertains to defamation. Now, I don't know that I have time. I'd like
give you 30 seconds to finish your thought.
Thank you, Your Honor. So the question as to defamation is whether the statement in question has a precise meaning, is it capable of being proven true or false, and does the context signal an opinion? All three of these factors come down very, very clearly on this phrase, facing a license suspension being a statement of fact. It's clear what's being conveyed. It's talking about a law license. It's clear, it's verifiable whether or not that was actually at issue in the California action, and there was nothing about the context of these ads to suggest that it was editorializing our opinion. Thank you very much.
Thank you. Serrano versus Brook Plaza. Counsel, I'm going to ask that you move as quickly as possible so the other party can get in.
May it please the court, my name is Daniel Kotler from Lester Schwab, Katz & Dwyer, on behalf of defendants appellants. Very simply, plaintiff in this case admits that he was recovered, rescued from the bottom of a 15-foot embankment on top of railroad tracks on somebody else's property, separated from my client's property by an abandoned lot and a high wall. Plaintiff, there's simply no way that that evidence in itself contradicts the possibility that plaintiff's accident occurred on my client's property, and therefore my client cannot be liable. Plaintiff did not claim that he had 2 falls or 2 accidents. He did not testify to that effect. He did not put in an affidavit to that effect in his opposition to summary judgment. Even if plaintiff's counsel's interpretation or attempt to save his claim were accurate, there's no way that he could have crawled his way over. If he could have crawled his way over and fallen down that embankment, then his injuries on my client's property cannot have been what they are described as.
But they could have been injuries. Perhaps there were modest, limited or modest injuries in accident 1, if you will, and then significant injuries occasioned by an accident that you have no responsibility for. But they're not mutually exclusive. There could have been 2 accidents causing varying a range of injuries.
So there are 2 responses to that, Your Honor. The first is that plaintiff simply never made that claim. Plaintiff never claimed that there were 2 accidents. That would have been very simple for plaintiff to have done, to have put an affidavit in saying, actually, I fell here and then I fell over there. Second, plaintiff can't make his case simply based on speculation. There's no possible way that you take a fall down a 15-foot cliff, a 15-foot embankment onto railroad tracks, versus, and say, oh, well, we're going to separate out the injury that you might have had, whatever minor sprain you might have had here, or even a fracture that came from the fall in the parking lot, versus the injuries from the huge fall down the embankment. Even if plaintiff had made the claim that there were 2 accidents, there's no way other than speculation to get there. And there's also the fact that plaintiff can't point to any defect on our property. Plaintiff said, oh, he used the word break, but in the context of it, which is a long discussion that I won't belabor, but we lay out the context in the papers, he's referring to the curb cut for the driveway, not an actual crack or break. And he can't point to anything. He says, what did you fall on? I don't remember. So there's simply no basis. He fell on the city's property somewhere else.
Doesn't the plaintiff identify the place where he fell and the break on 3 photographs?
He does identify the place, which he refers to as a break. But again, in that, well, he identifies the place where he alleges he fell. And he describes it as a break. But in the context of the testimony, which we lay out at length in our papers, and I won't quote in full right now because I know time is limited, but it's clear that he's referring to the place where the driveway breaks through the sidewalk. That is to say, the curb cut, the driveway where the parking lot passes over the sidewalk. He's not referring to an actual specific crack, even though his attorney prompts him to use the term hole, and he then even after he follows his attorney's lead to use that word, asked where it is or what to point to. He can't point to the actual supposed hole. He can't point to the crack. He says his words are, I don't remember. So even if it weren't incredible as a matter of law that he could have fallen here, even if it, in the AutoZone parking lot, even if it weren't complete speculation, even if it didn't require complete speculation for him to parse out supposed injuries from the former accident, he can't point to any defect without speculation. So his claim fails for all numbers of different reasons. Thank you, Your
Honor. May it please the court, I'm Annette Hassapidis, appearing for the plaintiff respondent here. I'm going to jump around and try to respond to some of the dialogue here. I've cited at our brief at page 14, I've cited to page 162 of the record. The problem here with this defect issue is that defense counsel never said, would you please put an X on the photograph where you see the defect? But at 162 of the record, the witness complies and identifies it in the defect, and plaintiff's counsel says, the witness is indicating it looks exactly like the middle of the paper on the line that appears to be an entrance to the garage parking lot. So he clearly identified the defect. Judge Higgett, as you pointed out, the fact that my client testified about 2 events doesn't mean that it's either or. The evidence is not, the two events are not mutually exclusive. The evidence has to be reviewed in the light most favorable to my client, and frankly, they relied on the deposition testimony of the plaintiff in moving for summary judgment. So by proffering contradictory information, including the photographs where my client identified the defect, they've defeated their own prima facie burden, which is what Judge Lubell determined.
The whole issue where they claim it really arguably the superseding event, the fall down the embankment,
right,
was raised for the first time on motion practice. It wasn't in the pleadings earlier on, correct?
Yeah, it was, they raised it in reply.
In reply, that's
Right,
what
in
I'm
their
saying.
main motion, they said, he fell in another property, we're not responsible. And he can't, and they characterized the medical record entries as my client's claims. They were not claims. And then they say in their motion, to the extent that he's now changed his claims, and he says that he fell on our property, you know, it didn't occur, his evidence is incredible. In reply, they make the superseding cause argument, which is problematic for a couple of reasons. First, they don't present any evidence to show, Judge Higgett, as you pointed out, that the injuries could only have occurred as a result of what occurred in the non-party's lot. Had they put in medical evidence that said, listen, these were his injuries and they're incompatible with a trip and a fall on a sidewalk defect or a curb cut defect or however you want to term it, I'd have a problem. But I would have put in medical evidence in opposition. I was denied that opportunity because they raised this for the first time in reply. There's no speculation here as to what occurred. There was no need, certainly, to allege that there was another event. This claim, this complaint, pleads the allegations against AutoZone. So the argument that I had to plead, or my client had to plead this other event, really makes no sense under New York law. This is a case that would be a half-a-day trial at most, when you look at it. The defendants, we're here on this appeal because of a flawed trial strategy, right? They deposed 5 non-parties. One of them was a former employee security guard. They don't ask that security guard anything at all about maintenance of the area. And that's why in opposition to summary judgment, we pointed out that notice was conceded here. They put all of their eggs in the basket of arguing. He was injured on the other property. His testimony is not credible, all of which was insufficiently proven or a matter for a jury trial. And that's really why we're here. They've changed their horse midstream, so to speak, faced with the fact that they don't have evidence to tether the injuries that my client has complained of with the second event. Judge Lubell was correct in determining that they failed to make out a prima facie case by relying on this inconsistent evidence. And I asked the court to affirm, based on the decision of Johnson, which is cited in our brief, it's 117 AD 3rd, 522, where the defendants had argued one cause of the accident, and there was evidence of another cause of the accident, and this court said that that was insufficient to support a summary judgment motion and deferred it for a jury trial. Thank you.
Your Honors. Yes, plaintiff brought this claim against AutoZone, and defendants made a prima facie showing that they can't be liable for plaintiff's accident by showing that it didn't happen on their property. Plaintiff never alleged, oh, the accident happened here and then it also happened somewhere else. Plaintiff could easily have opposed by saying that. We raised this issue of superseding cause for the first time in reply, because that's in response to the first time that the notion of 2 arguments was raised. The injuries that plaintiff alleges, there is no way that plaintiff could have somehow gotten himself over to this embankment, over a high wall, all of this distance, to then fall in. It's incredible as a matter of law. It doesn't make any sense. There's lots of cases, which we cite in our papers, that if something is physically impossible, which it would have been with the injuries plaintiff alleges for him to have gotten to the embankment, then it can't have happened. And also that if a plaintiff contradicts his medical records and the contemporaneous records of his statements, that is also grounds for incredibility or for feigned testimony. So on all of those grounds, defendants made their prima facie showing. They raised the issue of superseding cause in reply because that was the first time that anybody in this case, plaintiff's lawyer, made the argument that, oh, we have two cases. It doesn't matter what state or what the maintenance was of AutoZone's property if the accident didn't happen there. Thank you, Your Honors.
Thank you. Thank you both. Thank you, same to you. Kirby Forensic versus Carmi, KW.
Good afternoon, Your Honors. Dennis Fan on behalf of Carmi from the New York State Office of the Attorney General. I just want to focus on one critical piece of the respondent's psychological profile, which makes him categorically different than other sorts of respondents that you might see, and that really is his lack of psychological insight to understand what his uncontrolled psychotic symptoms are, to fully understand what his actual need for antipsychotic medication is, and to understand how his conduct, in fact, harms other people and has harmed other people in the past. Supreme Court erred in disregarding those aspects of his dangerousness, and those aspects of his dangerousness were supported by the unanimous clinical recommendation of the team at Kirby Forensic Hospital. I just want to start with his understanding of his active psychotic symptoms. He currently denies that he has psychotic symptoms at all. He denies that he's in treatment for psychosis in particular. That's an incredibly dangerous thing to let into a less secure type of facility where you're expected to have some degree of self-management if you then decompensate further in your psychotic symptoms. If you don't realize that you have psychotic symptoms and you start decompensating, then you don't even know when to start asking for the sort of help that you need.
Counsel, in this case, part of the problem was that he was not always medication compliant, right? But I think some of the evidence was that as of late, he had been medication compliant. How does that affect your argument?
That's right, Your Honor. He has been medication compliant with those medications that he has himself selected. So once his first treatment over objection order expired, there was a recommended increase of 5 milligrams of olanzapine or Zyprexa, and he was very much resistant to that increase. And I want to unpack a little bit. There are legitimate reasons why people don't like medication, but I want to unpack what his reasons are. He's described his medication as quote-unquote poison. He thinks his antipsychotic medication is dangerous for him. He thinks
that relates into your argument that he has just a total lack of insight, not only with regards to the incident with his girlfriend, but as to his own condition.
That's right, Your Honor, and that makes him a risk of then starting to not take medication again, like he has done in the past, which has resulted in these treatment over objection orders, which has resulted in things like needing to maintain a stricter medication regimen.
What's the legal standard here for determining whether or not the respondent suffers from a dangerous mental disorder that would require him to be treated in a secure facility?
It's just that he...
Is it a preponderance of the evidence?
Yeah, that's right, Your Honor.
Is that
the hospital bears the burden of proof on that. It's just a preponderance of the evidence, and it's whether he poses a physical danger to himself or others. And in this case, there's ample testimony talking about the various risk factors of dangerous. I mean,
was there any other psychiatrist, medical expert here? Was there testimony from...
There was no testimony from anybody else. It was...
Other than Dr. Chasen, I think?
It was Dr. Chasen from the hospital. There was no testimony from the other side. They had ample opportunity to present an expert to testify as to why he didn't, in fact, meet these risk factors for dangerous. His entire treatment team recommended this. The entire forensic hospital forensic committee unanimously recommended this. This isn't like one of those cases where you have internal disagreement between members of the forensic committee about whether somebody's dangerous. Everybody here on the medical side believes that this individual is dangerous. And really, in fact, what this type of person would need, what this respondent would need in order to move out of a forensic setting like this one, is to gain that sort of insight, is to start engaging in treatment, to have more than a superficial level of treatment, to understand his past crimes, to understand that he in fact did harm somebody else, to not deny responsibility by explaining that, well, I was just using jujitsu, or it was a high hug.
Were these ingredients of Dr. Chasen's opinion?
These were ingredients of Dr. Chasen's opinion. She very much faulted this particular respondent for not ever kind of coming to terms with his past violent conduct. I see my time has elapsed.
You have rebuttal.
Good afternoon, Your Honors. May it please the Court, I'm Michael Degree, appearing on behalf of the Appellant Nassau County District Attorney's Office. Your Honors, diagnosing and treating people suffering from mental health issues is not a simple or straightforward task for the doctors, nurses, psychologists, and various other healthcare professionals that are trained in that field. And there are no quick or easy answers with respect to treatment, and that includes therapy and medication or a combination of those two things. It is therefore necessary and appropriate that we rely on those professionals for their expertise, because they are in the best position to help the people that need it the most. And this case is a prime example of that. Here, Dr. Chasen reviewed the respondent's medical records and personally evaluated him 2 or 3 months before the hearing. Her testimony reflects that the respondent has had good days and bad days at Kirby since the date of the prior retention order, which was in September of 2021, and which are also documented in the medical records that are in evidence. And during that period, the respondent, at times, as Dr. Chasen acknowledged, was able to acknowledge some of his symptoms, was cooperative, and did make an effort to engage in his treatment. However, at other times, on bad days, the respondent expressed that he's not dangerous, that he doesn't belong at Kirby, and he does not have a mental illness. His medications are bad for him, and that he doesn't need to take them. His peers harass him on the ward. And these are all examples of his psychotic thinking and other delusions that he has experienced throughout his time.
It seems like the judge made the distinction between a mental disorder and a mental illness.
I'm sorry, Judge.
I said it seems like the judge, in making a determination, believed that the individual did not suffer from a dangerous mental disorder.
That's correct, Judge.
And instead suffered from a mental illness.
The judge did make that finding. That's correct.
That seems to be the basis for his deciding that it was okay for him to be in this sort of step-down facility. Was there anything from any medical professional, the psychiatrist or anyone else, to support an illness versus a disorder?
No, Judge. There's nothing in the record or from the testimony offered by Dr. Chasen that supports that the respondent suffers from a mental illness as opposed to a dangerous mental disorder. The hearing court's opinion that the trajectory of the respondent's medical treatment was in a positive direction is actually contradicted by the record and the medical.
And would that be enough, that it was going in a positive direction?
Absolutely not, Judge.
Thank you.
Thank you.
Good evening, Your Honors. I'm Diane Tempkin for Respondent Carmi KW. And the evidence here shows that Carmi's level of dangerousness has lessened. And what's at issue here is the level of dangerousness, whether it's still at the heightened level or whether it's now lowered. And the legal standard is stated in the pleadings on page 244 of the appendix, where it says that the issue is whether Carmi W. has a dangerous mental disorder or is mentally ill, as those terms are defined in Criminal Procedure Law 33020 and as interpreted by the cases George L. and David B. And in David B., it clearly states that there are two levels of dangerousness: the heightened level of dangerousness for dangerous mental disorder and a lower level of dangerousness for the mentally ill standard, even though it's not in the statutory language. And that's important because if there is no dangerousness found at all, he would have to be released. Those are the three dispositions in this this application for continued retention. And the evidence did show that Carmi's level of dangerousness has lessened. Kirby's doctor testified on direct that he's presently complying with all the psychiatric medications being offered to him at the proper dosage. That was the evidence. It was repeated more than once by Dr. Chasen.
Counsel, didn't this individual have a history of medication noncompliance, so that present compliance may not really be indicative of long-term proper compliance?
Well, in fact, Kirby had stipulated to vacating a forced medication order because Carmi was taking his medicines voluntarily. And this is only about transfer to a civil facility where they could bring another medication order to force him to take medication. This isn't about going into the community. This is only a very small step that would lead to the civil facility that would put him on a path for more liberty. And there would have to be more court authorizations for any other kinds of steps. So this isn't really about whether he would be non-compliant in the community. He's still going to be in a mental hospital.
But medication noncompliance and threats of future noncompliance, or even that there isn't a threat that he's, those kinds of things, I should say, can be considered in making a determination as to whether or not to transfer him to the step down. I mean, aren't those things permissible bases for making the determination?
Well, the George L. factor is a history of noncompliance and future threats of noncompliance. And in some of the cases, the person said that they wouldn't take medicine, they didn't have to take medicine, or they were programmed to say they would take their medicine. And here you don't have that. You have Carmi saying that he knows he needs to stay on medications for the rest of his life. So the George L. factor is past noncompliance and possible future noncompliance.
But isn't there possible future noncompliance with a person who is inconsistent with that, even if they've been for a little while consistent?
Well, it just goes into speculation at that point, really. And also, the last retention order was only for 1 year. The judge, a year before, thought that he didn't need to be in. He was getting better.
Counsel, isn't this all complicated further by the fact that the patient here has a total lack of insight with regards to his own mental illness and the underlying incident?
On page A46 of the appendix, the doctor testified that he had some insight. It's not that he had no insight. In fact, lack of insight, this court has found in Glen B, it means that the person needs to be in the civil facility, and that's what that case found in Glen B. Total lack of insight could mean civil retention. Here, the evidence is some insight, and
What legitimate or principled basis would we have to disregard Dr. Chasen's opinions?
well, it has to be based on facts, or else it's worthless. And the facts here in the medical records do not support what the doctor testified to, because she admitted that he speaks about his mental illness now. He knows his symptoms. There's evidence that he knows he's being treated for psychosis. He knows he has schizoaffective bipolar disorder. He plays guitar in groups. He shows no aggressive, violent, assaultive, abusive, or argumentative behavior. whereas years ago, he was not engaged in treatment, and he was denying that he had a mental illness, and he didn't want to take his medication. And now he's not like that. The appellant's theory is he's exactly like that, and he hasn't made progress. And that's why that you don't have to consider the expert's testimony here. And also the fact that our side did not have an expert is not indicative of that, like we couldn't find an expert. There are other issues that have to do with that aren't attributed to that. So this court shouldn't take that inference.
Can I just, I'm sorry I'm just going to ask you just a question on, you say that he's taking the medication now. The order requiring him to take the medication is lifted for now. But what about, I guess it goes to insight that's already been asked. But so you have somebody in the step down. This has already been discussed, but I don't know that you addressed it specifically. You have somebody in the step down who is not aware or is not, coming fully to terms with or has a lack of understanding about how his illness has contributed to his violence in the past. And the step downs are step downs because they have less security, there's more freedom to, go around the facility. How, without that level of insight, isn't there a real problem, potential for dangerousness with this
Well, first of
individual?
all, the evidence here on page 87 of the record is that he would still be in a locked ward for CPL patients, so he doesn't have the freedom to go around. He would need court authorization for a different further court hearing for any kind of more freedom. And if somebody is unmanageable in a civil facility, they can be transferred administratively in an instant back to the secure. The regulations cited in my brief, and it's also cited in the Court of Appeals case, David.
I guess the question is if he's articulating that still. Isn't that, I said, I guess the question is if he's still articulating that, does that not, weigh against his going to the.
But he's not articulating that. He's admitting he has a mental illness and will always have to take medicine. And he admits he has a psychotic issue. And in fact, he told his treating psychologist that he had, a psychiatrist, that he had auditory hallucinations 3 to 4 months before the hearing. And that demonstrates insight and honesty because he knew that that wasn't reality. It's not like he thought that that was his reality. He was grounded in reality, and yet being on medication, completely compliant, he had an auditory hallucination, and he didn't act on it. He said it was milder than it once was, and he told his psychiatrist, which is what somebody does when they have insight, because they recognize what's a hallucination and what is reality. And he did demonstrate insight, and the doctor testified that he did have some insight.
Okay, thank you.
Just a few small points, Your Honor, on whether he realized.
Well, counsel, let me just ask you, this facility, this step-down facility, it is still a state facility, and counsel has indicated that if there should be an issue, he would be returned to the facility immediately.
Your Honor,
the more secure facility.
I think that.
So when does a person like this, what more do they have to demonstrate to be able to be in a lesser facility?
So just to answer that part in that question, 2 parts, I think that really does put the cart before the horse. Because every single person, you could say, well, you could just move them to a non-secure facility.
No, I'm not talking about every single person. I'm talking about this person
And then
who now does not need an order to force him to take medications, who has now, while does not have complete insight, that's for sure, has a level of insight that may make him at least aware of most things, related to his being at the facility.
So
His girlfriend or whoever it was is not at the facility, so that would not.
So I think the thing that you pointed out, insight, is exactly what he needs, and I do want to correct a few things that counsel on the other side did say, one of which is that he doesn't have insight into his psychotic symptoms. If you look on page 129 of the record, when he's asked about whether he thinks that other people are reading his mind, for instance, he testifies at the hearing, no, I don't think that. That's not what I'm thinking right now. That demonstrates a lack of insight, especially when his treatment team has found that repeatedly he has hallucinations. The next thing is you'd have to have insight as to why he's taking medication in the first place, not just being compliant because he feels like it or being compliant because he knows he can get into trouble. And I just want to point out real quickly one page, which is page 128 of the record. And he says, my medication is for my sleep, my appetite, and my mood. That is far different than a sort of patient who understands that their medication is there to help stop them from becoming a danger to others. Thank you, Your Honors.
Thank you.
To your point, Judge, about the medication compliance, yes, the treatment over objection was lifted upon agreement, but as we point out in our briefs, he's on a long-term injectable medication, and the reason for that, as Dr. Chasen explained in general terms, is because there's a fear that he will become non-compliant. So he gets a long-term injection once a month as opposed to other types of medication that he could cheek or not take on a daily basis. And that's all I have to say, Your Honor, and for those reasons, you should reverse. Thank you.
Thank you. And last but not least, Haverty versus the City of New York.
Good evening, Your Honors. My name is Farooq Yusar. I represent Petitioner Appellant Mr. John Haverty. Your Honors, this court should reverse the motions court order for mainly 3 reasons. The first reason is the motion court did not accept petitioner's allegations as true. Under the well-established motion to dismiss standard, this court, as well as the motion court, must accept petitioner's allegations as true and draw every inference in favor of petitioner.
Let me just try to, narrow this a little bit. So this particular action is an Article 78, in addition to a declaratory judgment action.
Primarily a declaratory judgment action as well as Article 78.
Yes, and
Correct,
so with regard to the Article 78, there are 4 months. They're very strict rules. You have 4 months to appeal.
Yes, Your Honor.
And you are challenging the RFP of the New York City Department of Transportation, right?
That is inaccurate, Your Honor.
Okay, make it accurate for me. Tell me what I'm missing there.
Your Honor, RFP relates to the 2012 agreement for bike share program. It has nothing to do with 2014 amended and restated.
Okay, let's talk about the 214. There was an amendment in 2014. You're challenging the amendment from 2014?
That is a novation. That is correct, Your Honor.
But how do you have standing to challenge this October 2014 amendment between DOT and New York City Bike in 2022 or 2021 or October of 2021? That is, that would be still a 4-month standard, and we are far beyond any such thing.
Your Honor,
statute of limitations is what I mean. I said standard, but.
As to petitioner's Article 78 claim, is that your question?
Right, exactly.
Yes, Your Honor. First and foremost, Your Honor, the petitioner is challenging the municipal agency, Department of Transportation's authority to lease inalienable city property for which there are no statute of limitation. Under the Faison versus Lewis and Capruso versus Village of Kings Point, absolutely in the state, there are no statute of limitation for a municipal agency's lease of inalienable city property.
That's your argument for, why don't you go ahead?
Your Honor, that's...
I'll give you 30 seconds, a little bit more time to sort of explain your position.
Yes, Your Honor. The second point, and most important, this is a declaratory judgment action. Respondents invoke the contract in the negligence action in Kings County Supreme Court.
Yes.
All petitioner is seeking is to have this court declare that this agreement is a lease agreement. And since it's a lease agreement, and we are also asking this court to declare it null and void from the inception under the applicable law, Your Honor.
Okay. Thank you.
Thank you.
May it please the court, Kate Fletcher for the municipal respondents. As the court indicated, there's a 4-month statute of limitations in an Article 78 that has long passed, regardless of whether you start the clock when it accrued during the RFP in 2010, or at the 2012 contract, or at the 2014 amendment. With respect to the declaratory judgment portion, because the relief that petitioner seeks is available in an Article 78, the same 4-month statute of limitation applies, and the same is true for the restitution claim. In addition, the plaintiff here lacks standing because they failed to allege an injury in fact at all, let alone one that falls within the zone of interests of the City Charter 384 competitive bidding provisions. If there are no questions from the court, the respondents rest on their briefs.
Good evening. May it please the court, David Kiko for the respondents, New York City Bike LLC and Lyft Inc. The only thing I would like to add to what the city has argued is that there is the issue of third-party beneficiary. So this goes to the standing issue. In order to have standing, you have to either be a party to a contract or be a third-party beneficiary. It's a 3-part test. I'd like to just mention the second part, which is on the face of the contract, the party has to show that they are an intended beneficiary. I'd like to read the court a provision which is identical in both the 2012 contract and the 2014 contract. And it simply states, the provisions of this agreement shall not be deemed to create any right of action in favor of third parties against New York City Bike or the city or the respective officers or employees. And that's the record at 176 and 325. We would ask that the court affirm the decision of the motion court, and if your honors don't have any further questions, I rest.
Thank you.
Thank you, Your Honor. Your honors, have a happy Thanksgiving.
Thank you. Same to you.
Justice Rang, I would like to expand on your question a little bit more. We have several amendments to the 2014 agreement for bike share, amended and restated agreement for bike share program. And as recent as a few months ago, well, actually since October 1st, 2021, this agreement was assigned to another party. So what we have is an entirely new agreement. So if we, which this court should take as the starting point for the purpose of statute of limitation, the assignment date, then the petitioner is within the statute, within the 4-month of statute of limitation, Your Honor. For the, if Your Honors don't have any questions, I defer to my filings, and I respectfully request that the court reverse the order, Your Honor.
Thank you. Thank you all.
Slow at 10 a.m.